Basically, the matters are sent back to the review authorities, calculated. Okay, calculated, and demand notices are set aside, and it has to be calculated. But one portion of land that will be taken is taken that cannot be taken as a fresh. Fresh allotment that will be taken as a pending allotment, and the other portion wherein there is no agreement that will be taken as a fresh allotment. And in terms of the surplus, it will be calculated, and that will be done by the railway within a period of 3 months. Okay. So it's allowed kind of. 47 also same. 47 is also same. There was no agreement here, so the fresh agreement, if required, this agreement has to be getting.
If I may, my lord, I beg to mention item number 12, my lord. I'm for the petitioner. I have obtained consent from the opposite party.
Yes.
My lord, item 12, my lord.
You are appealing for?
For the petitioner, my lord.
Ah.
My lord, I beg to mention this matter, my lord. It may
Your name?
G. Imtiaz, my lord.
G. Imtiaz, the learned counsel, appearing for the petitioner. Petitioner prays for adjournment of the matter for 2 weeks.
My lord, may be fixed on next week, my lord. Admission matter, my lord, it has not come up yet. Preferably on Tuesday, my lord, if it is.
Prays for adjournment of the matter, which is not opposed by the council, appearing for the other side. Let the matter be listed on 9th of June.
Deeply obliged.
Please, Your Lordship, I beg to mention item number 23. CD has not received in this case, Lordship, and similar matter has been filed before this honorable court arising out of same FIR, Lordship. BA number 1266/26. This matter may be taken along with BA number 1266, Lordship.
MS the learned counsel, appearing for the petition, submits that another matter, that is bail application number
1266
arising out of the same FIR is pending before this court. She prays for listing of both the matters together. Both the matters, that is AB 015/2026, as well as the other case number, right? As well as so and so, to be listed on 11 June. 11 June.
Yes. I beg to mention item number 16, 16,
Lordship,
6, yes.
kindly interim order may be continued.
Interim order so passed in AB 015/2026 shall continue till the next day, of listing.
Item number 16, my lord. Can be adjourned, my lord. I have some difficulties to them, my lord. Come up after 1 week, my lord.
Huh?
Receive the case.
After 1 week. So SM Mullah, the learned counsel, appearing for the hearing of that. It gives that meets fees for adjournment of the matter. Is allowed, let the matter be listed in the next, in the next week. 15 minutes.
Obliged, my lord.
Mr. Lordship, I beg to mention item 15 of today's list, Your Lordship. I may be allowed to withdraw on instruction, Your Lordship.
15.
One five.
MSF Hussain, the learned counsel, appearing for the means that she has instructions to withdraw in case. The bail application is dismissed from withdrawal.
Obliged.
My lord, I beg to mention for item number 13, my lord. My lord, may kindly fix this matter on 12th June, my lord.
Why 12 June? Why not today?
My lord,
Why are bail hearings?
some difficulties there, my lord, that's why.
Ms. SD Chaudhary, the learned counsel, appearing for the please for adjournment of the matter. Let the matter be listed on
12th June, my lord.
12th.
Obliged.
I beg to mention item number 7, my lord. I may be allowed to introduce petition which will party to file a case, my lord, because there is a advertised error, my lord, while drafting the petition. I may be allowed to introduce.
Mr. D. Gogoi.
Lordship, D. Gogoi.
D. Gogoi, the learned counsel, appearing for the accused applicant. Submits that he has instructions to withdraw from the case. Disseminate bail application. He raised goodwill of the matter, delivered to file it, raise as due to something inadvertent without economic. Instant bail, instant ABF. Matter is dismissed with the liberty file it. To file a fresh is if so priced.
Deeply aware.
Let me give us it. So, Lordship, I'd like to mention one part hurt matter, my lord, for listing. It was fixed on 28th of last month, but due to the occasion of Eid, it was a holiday, Your Lordship. So can it be fixed this Thursday?
Which one? Which one? Which one?
It's a part hurt matter,
Which one?
this Thursday, man.
Which one matter? Which matter? We'll have to know which matter.
Oh, matter is related to,
Tell me the number.
is the, well, this,
Without a number, how it will be listed?
my lord. Just a moment.
This is not the way to do it. Leave it, leave it.
Yeah, please, Your Lordship. Lordship, item number 43, my lord. Your Lordship may not like to take up the matter as told me by the petitioner's counsel, appeals counsel, Mr. J. Kalita.
Okay. Release this matter before next year. Okay.
Deeply aware.
Please, my lord. My lord, its number is WPC 3403 of 2019.
Party,
Petition. for the-
party's name.
Pradeep Shah versus State of Assam in Prohibitions. Part hurt in this book.
Pradeep Sam. Who are the councils?
For petitioner is NSAK for the petitioners.
Okay.
Can we listed this Thursday? This Thursday? Fourth.
This Thursday, no, next
Tuesday?
next Tuesday.
Tuesday. Not fixed.
Tuesday.
May I please? I beg to mention item number 43.
43.
Yes, sir. Kindly the matter may be listed before any appropriate.
Already mentioned. Already mentioned.
37 also same loss if I am going to file document 37.
Huh?
37.
37 also.
So lots I am going to file document number today. So lots of matter different in other
Okay, 37 also pass the same mark.
lots.
Before next.
Four 39, man. He's already in his 108 abatement to suicide.
Hmm?
Abatement to suicide. 439, he is already in custody. The FIR is of 21/3/2026.
21-3.
2026.
Hmm.
He was arrested on 27/4/2026.
27-4.
2026.
26.
Yes.
Hmm.
He was taken to police custody for 2 days.
Hmm.
Thereafter, he is sent to judicial custody. Till today, he is in judicial custody, my lord. Now, if your lordship looks into the FIR, my lord, which your lordship will find at page 14, my lord. Page 14.
Yes.
I'll just tell in short, my lord. It's about running about one page. If your lordship want to read it, I can read this FIR.
Please read it.
I'll read or my lord.
You can tell me.
My lord, the facts is this, my lord.
Hmm.
The petitioner
Hmm.
is the owner of a shop.
Hmm.
A co-owner is there.
Hmm.
Now, this deceased,
Hmm.
my lord, he was an employee of this of our the shop.
Hmm.
So he was called on 19th of March,
Hmm.
2026.
Hmm.
He was called in his shop,
Hmm.
and he came in the shop, and they found
Hmm.
that somewhere 20 lakhs was misappropriated by this boy.
Okay.
Then, my lord, the case of the informant, the deceased father,
Hmm.
he is saying that he was called.
Hmm.
Subsequently, he was beaten,
Hmm.
and thereafter we called the police
Hmm.
on the same date.
Hmm.
Police has taken him not in the police custody but police station.
Hmm.
Now, thereafter, he has given an undertaking to us
Hmm.
that 20 lakhs will not be possible.
Hmm.
We will pay 10 lakhs.
Hmm.
And out of 10 lakhs, 1,70,000 was paid.
Hmm.
Remaining is to be paid, and there is an undertaking
Hmm.
which is given by him before the police. If the lordship looks into at page 37. We also lodged an FIR thereafter on the same date
You lost for what?
I'm sorry, we lost an FIR because money was misappropriated.
Hmm.
So our FIR is not registered, but they have received at page 35. Now, if your lordship looks at undertaking at page 37,
Hmm.
I, Medul Soikia, so and so give assurance to pay 8,30,000, which money was stolen by my brother. I shall return the said money in the installment of so and so. Said I shall pay aforesaid amount either to see so and so, that is the petition of my lord, or not before fixed date. So this is my lord.
But this is dated.
I'm sorry, my lord.
This is not dated. The document is not.
No,
dated.
next page, man.
Is there a
Next-
date?
Next page, my lord.
Yes.
The original is at page 38.
Yes. Where is the date?
8 to 9.
The date is
That is not.
date is
before-
missing, Mr. Das.
Yeah, correct. Your lordship is right. Lordship is right. Date is missing. Now,
Money receipt is also.
my lord is okay, fine, my lord.
Hmm.
My lord, we have to see it on the basis of that.
Hmm.
Now, in the FIR, if you see the FIR, my lord, at page 14.
Page 14.
Yes. Page 14.
Yes.
It is admitted by them. If you turn to page 15,
Hmm.
please see, after 1, 2, 3, 4 line, the accused demanded
Hmm.
an amount of 20 lakhs
Hmm.
from my son and threatened to kill him if the amount was not paid. Thereafter, in presence of police personnel of so and so, matter was settled through an agreement, whereby, lordship got it, whereby we agreed to pay 10 lakhs.
Hmm.
By paying an amount of 1,70,000
Hmm.
to the accused, we secured the release of my son and assured payment of remaining amount of 8,30,000 at a later stage. After bringing my son back from the custody of the accused continued to be threatened him repeatedly. Unable to bear the mental pressure and trauma caused by such threat and the physical and mental torture inflicted upon him, my son committed suicide by hanging himself at our residence on 21/3/2026. This is the case.
Mr. Das, I mean, case that will be required in this.
I'm sure, my lord, your lordship has to call for the case.
We'll give a short date.
Yes, yes.
We'll ask for the case.
Because I found a judgment of the Supreme Court also. If it is a loan, like, and there is a amount of payment has been demanded and he could not pay, and there he commits a suicide, that doesn't amount to abatement of suicide, man.
Yeah, but
So-
it's a tricky affair.
Yes, 107.
It's
107.
a bit tricky.
Yes,
So
because there will be no witness to it. Abandonment, rape, there will no witness. But there is no suicide note also has been not been left. But even then, if your lordship wants, your lordship can call for the case there, give a short
see
date,
the
a week
CD,
time. Because he is already in custody for 37 days. man.
37 days.
37 days, man. So a short date, if 1 week, man.
Date will get.
Yes.
How much time will you require, Mr.
Scan copy, scan copy.
Huh?
It is from Lakhimpur, my lord.
Lakhimpur.
Scan copy, my lord, they can bring the scan copy.
Okay, you write hard Mr. D. Das, the learned senior counsel, assisted by Mrs. Surana and Surana, the learned appearing for the accused applicant. Also heard Mr. D. Sharma, the learned APP for the state. This is an application under section 483 of BNSS 2023 for granting regular bail, for granting bail to the accused applicant in connection with Laluk PS case number 62/2026, registered under section 108 of BNS. An FI was lodged on
FIR laws 21/3/2026. Your lordship will find 22, sorry. Your lordship will find at page 17, date and time of FIR 22/3/2026.
22/3/2026 by one incident by one Kogan Soikia alleging entirely that that his son, who was walking in the shop of walking in the shop, the accused person for for about 1 year and 6 months. Semicolon that, that 19/3/2026, his son was at home when the accused called him over the phone and asked him to come to his shop. That semicolon that about 4 a.m. on the very day his son left for the shop, and about 11 a.m. on the same day he received an information over the phone that his son had stolen some goods from the shop, and because of that reason he had been confined there. Semicolon. That the informant, along with his family members, went to the shop and found his son confined in a room after being assaulted. That the informant and his family members found his being assaulted. Found his son had been assaulted by beating up with pails and sticks. That the accused demanded an amount of rupees 20 lakhs from his son and threatened to kill him if the amount was not paid. That in presence of the police person of Nizuli police station, the matter was settled through an agreement whereby the informant and his family members agreed to pay rupees 10 lakhs accused. That by paying an amount of 1,70,000 to the accused, the families of the informant's family got the release of the son of the informant and assured them to pay the remaining amount of rupees 8,30,000 at a later stage. That after he was taken home, he had been continuously treated by the accused persons and unable to bear the mental pressure and trauma caused by such threats and physical and mental torture. The informant's son had committed suicide by hanging himself in their residence on 21/3/2026. On receipt of the FIR, the police registered the Laluk PS case number 62/2026, and the accused applicant had been arrested on 27/4/2026, and since last and since then he's behind the bars. He's behind full stop. Call for the CD. Call for the CD. Let the matter be fixed on
11, 12.
12 June.
12 after 8 or 9. 8.
8 or 9, CD may not come, Mr. Das.
The scan copy only.
Scan copy.
8 possible আছে 8 8
10.
10 না সাকো 10 long.
Okay, 9th of June, 9th of June.
9
9th.
the plea of
May I please, Your Lordship? Lordship, in this case, the petitioner is behind the bar for last 26 days, my lord. Unnecessarily, he is languishing behind the bar, my lord.
Unnecessarily.
Lordship,
Yes. Now explain why unnecessarily.
Lordship, I'm explaining, Lordship. In this case, the informant lodged an FIR stating that she has adopted one girl, my lord, at the age of 10 years. Lordship will find the FIR at page 8. But he does not disclose that at present her age is 28 years, my lord. And she has got married the accused number 3, my lord, Ratan Rao.
The allegation, you tell me that.
No, I have annexed the photocopies of the marriage, my lord.
Can you tell me that? I was
Lordship,
thinking.
allegation is that, my lord, lordship will find the FIR as a page. May I read, my lord? Respectively, back to state that at the age of 10 years of Lipika Roy, her father died. Later, when her mother was facing difficulties to nurture her daughter, then she handed over her nurture her daughter. Then she handed over to us. Then we nurtured Lipika Roy, got her education and grown up in our house. On 1/5/2026, after 6 p.m., the girl was suddenly disappeared and from our house. Later on, after making some investigation, we came to know that on 1/5/2026, the aforesaid accused persons came by a four-wheeler car and by convincing her taken away with them.
Okay,
Now,
heard Mr. So-and-so, heard Mr. Your name?
Lordship,
Your name?
B. Chanda, my lord.
B. Chandra, the learned counsel, appearing for the accused applicant, also heard Mr. B. Sharma, the learned APP for the state. Is an application under section 483 of BNSS for praying for granting bail to the accused applicant in connection with reviewing her PS case number 127/2026 registered under section 61 in bracket 2, bracket A, stroke 127, bracket 2, stroke 143, stroke 127, bracket 3, stroke 3, bracket 5 of BNS 2023. An FIR was lodged on
6/5.
FIR was lodged when?
6/5, my lord.
Huh?
6/5/26. The alleged incident.
Yes, 6/5/2026 by informant namely Arup Kumar Bora, alleging that girl of 10, a girl who had been staying with them suddenly disappeared on 1/5/2026. It was alleged that after certain investigation, it came to the light that on 1/5/2026, the accused persons named in the FIR came by a four-wheeler car and luring her, took her away. It was alleged. It was also alleged that the girl must have been taken by the accused persons for the purpose of involving her into prostitution. On receipt of the FIR, police registered the Gauhati PS case number 127/2026. All for the CD, let the matter be fixed on.
My lord, a short date, my lord.
12.
12.
Wait, please, lordship. My lord, item number 48 may kindly be taken with item 35 and 36, your lordship.
35 and
36, your lordship. Arising out of same affair, your lordship.
35 and 36.
36, your lordship.
Okay.
So, item 48, your lordship, was arrested.
Come in this.
Not to ship.
CD hasn't come. We'll call for,
Lordship, a short date may kindly be given, your lordship, because 17 days time took you, lordship. 17 days for case diary took time.
17 days they have time.
Yes, your lordship, for case diary, your lordship.
17 occasions you are saying.
No. Total 17 days, your
You
lordship.
said total 17 days above. I'm shocked. 17.
No.
They have taken time.
No, lordship.
Hmm?
Because 15/5/2000.
Okay, heard Mr. A. Diwan, the learned counsel, appearing for the accused applicant. What is the FIR?
FIR is at page, your lordship, page 9 to 14, your lordship.
What is the allegation?
Allegation is, your lordship. Allegation is that, may I read, your lordship, page 10, your lordship. With due respect, I beg to state that
You
due to
tell me what happened.
your lordship on 6/5/2026 attorney
allegation is that the accused person, they armed with some lethal weapons, your lordship, entered into the premises of the informant, your lordship, and your lordship, smeared silly powder on the eyes of the body of the brother-in-law, your lordship. And as a result of which, your lordship,
Attempt to murder is there.
Attempt to murder, murder of the informant.
Yes, Lordship, it's a, in a mob, Lordship, they were attacked.
Then my mother-in-law, Mr. Hart, Mr. A. demands the learned counsel, the accused. Accused applicant also had to please not the learned for the state. Equity for the state. Is an application under section 482 of BNS, BNSS. For paying for granting bail to the accused applicant. In connection with Moirabari PS case number 46/2026 under section 190/1/1/8/329/4/310/2/74/109 of BNS. And of course laws on 7/5/2026 comment raising that applicants came with armed weapons to our house. The house in an we can came to her our house and attempted to kill her. On receipt of the FIR, raised the Moirabari PS case number 46/2026 under the aforementioned sections. Call for the case, call for the son. Then you write, list this matter along with AB application number 1003/2026 as well as bail application number 1221 of 2026 is in out of the same.
maybe on 8th, your lordship, on Monday.
12, Lordship.
12th of June. 12th of June. Three matters are there, 12th of June.
Obliged.
Oh, FIR, Lordship, apprehension of arrest.
Okay. So we'll take it after some. Or
The positive mail application. FIR is phase 10, lordship. Mary. Mary, lordship.
yes,
The humble summary is that the so is it about 15 years was my daughter who was reading in
name Nur Muhammad.
Muhammad.
Named in the FIR.
Yes, accused
Lordship.
number 2.
It is number 2, lordship.
Okay.
As per FIR, lordship, the allegation against the accused number 1, lordship. The accused number 1 with a bad intention as well as deceitfully approached my said daughter to develop love affair and went out for moving. And the accused number 1 took some obscene and objectionable pictures in his mobile against her will. My daughter informed us that the accused number 1 had threatened to my daughter with a view to kill her, while my daughter objected not to take her pictures. The accused number 1 started to viral the objectionable pictures of my daughter in the social media. My daughter requested the accused number 1 not to viral the pictures in the social media, but the accused number 1 did not any response, and the accused number 1 compelled my daughter to commit suicide. Next, the accused number 2 was running a grocery shop at so market without any license. Actually, I have taken license, lordship. Sold fertilizer and insecticide poison along with grocery articles.
So I mean, we don't have any case for anticipation.
The FIR incident, as per allegation, lordship, the incident.
No, that
2015.
why did you sell the fertilizer to a
I have a very
young girl?
lordship.
Without any, you need a permission and you need a permit to buy those things. How can you sell those-
Annexure number 2, lordship.
how can you sell those things?
I have a license, lordship.
You have a license, but like whether you have, I mean, have you, whether you check, how can you sell this to a minor girl?
Minor girl.
Not, I have never sold any articles to any minor lordship.
Then who, you have sold to whom?
Some person lordship in the marketplace lordship.
She has, I mean, this allegation has been wrongly made to you.
Lordship.
Huh? Who
Lordship.
has wrongly made? Is there any enmity?
No, lordship.
Then why you have somebody will take your name? All of a sudden?
So only my scope is the
Just
in the locality lordship.
say that like this person has killed me.
Only is the scope in the locality lordship.
Have any,
Lordship, the incident took place in the June 2015 lordship.
if you have any case, you face the trial, but not at this stage, not at this stage. You will not get any liberty at this stage.
You kindly see the incident took place on 15 June 2025.
Yes.
The FIR lost 9th of February 2026 lordship. After 9 months lordship. Earlier they filed a FIR
Earlier they filed a,
FIR lordship.
earlier they filed an FIR.
FIR lordship.
Where?
Paragraph lordship 11, page number 11 lordship. Last paragraph. Due to unnatural death of my daughter and getting information about the incident, I filed Izehar before Borbada Sodar police station, but justice was not given. As a result, I compelled to file this present FIR lordship. Earlier they filed the FIR, nothing has been done. Subsequently, they filed the FIR against the implicating the petitioner number
That
2.
is why, I mean, like the FIR was filed, but nothing has been done. That's why he has to file it again.
That's why I have a very license lordship and
Where is your license?
is 21 lordship. It's a 2. Issued by the sub-divisional officer, agriculture, Borbada lordship. For a period of 5 years. It's on 23/11/2021.
Okay, we'll see the seal.
So interim petition may be given lordship.
No. Third, Mr.
Amjad.
MJ Shah, the learned counsel, attending for the accused. Also third, Mr. B. Sharma, the learned deputy. That's great. Reason section 480 for BNSS 2023, paying for PRS bail to the accused applicant in connection with Bogota PS case number 71/2027. 296/7, stroke 108, stroke 123, stroke 35 of BNS. Fire was lost on 9/2/2026, releasing the accused, acknowledging that the accused applicant herein had sold in fertilizer and certain fertilizer and insecticide along with his grocery articles. And his minor daughter consumed after buying some fertilizer insecticide, committed suicide by consuming the seed. Call for the CD, let the matter be listed on Mr. Sharma, when 9 or before that 9? Okay, 9.
I'm sorry, my lord, that I was thinking that my item is 4. My lord, the petitioner is seeking anticipated bail pursuant to a raid, my lord, by raid done by police of Amingao police outpost, my lord. My lord, what happened, my lord, on 2nd of May, the petitioner was asked to appear before the outpost, saying that one Ratul Soikia has lodged an FIR against him on the pretext of, my lord, some misappropriation of fund. My lord, the petitioner was earlier.
Where is the FIR?
FIR is not, my lord. We could not trace out the FIR, but police is searching me My lord, I have inquired with the, my lord, Amingao police station. I mean, my lord, not, Guwahati police station, my lord. But, they have not provided any information, my lord, and thereafter, my lord, the
Have you submitted any application? Or have you submitted any application or something
Application.
before the police station?
application not submitted, my lord. No, my lord.
How then, like, without any material, you will be given a protection?
But my lord, the
Don't create a trend wherein, I mean, you do not file any application with the police station. You
my lord, I have,
straightway come and say that like their police is searching you, then you should be protected. It cannot be done like that.
at this stage, my lord, they may take instruction at this stage.
No, forget about they are taking.
No, I have categorically stated,
Your right. What is your right to come to the court?
my lord, I have stated that my family members, my lord, they went to the police station, my lord, they asked for,
But you haven't put in effort. You haven't shown to the court at least to show that you have put in some effort to get the FIR or whether the case is lost or not, some information. It is your application.
application not filed, my lord, but I have inquired, my lord, through my,
That you have inquired, how this court is going to know?
my lord, at this stage, my lord, let the PP, my lord, take instruction whether any FIR has been lost. If there is no FIR, my lord, then my lord,
Okay, right. Heard, Mr.
M. Ali.
M. Ali, the learned counsel, appearing for the application. Is applicant. Also heard Mr. B. Sarma, the last basis of the school. Is an application. Section 48.
Not I mean, go
Granting of players to the accused applicant, who is apprehending arrest in connect with you have stated that if FIR is filed.
The police informed me over telephone, then one FIR, one Ratul Soikia, my lord, he has lost FIR against you.
Everything is there.
But my lord,
They are aware, Lordship, that FIR has been lodged.
The FIR is.
is informed, but no FIR has been registered yet, my lord, as because my lord, I have stated, my lord,
FIR lost against.
in para 4, my lord, I have stated my family members went to the.
Then with an FIR lost against the accused applicant. Accused applicant by one Ratul Sekia. Ratul Sekia. The learned counsel agreed to business means that in spite of their best report, they could not get the details of the FIR. They could not, they neither could get the copy of the FIR, nor the details of the FIR. However, police is searching for him and visited his house many occasions, and therefore he has serious apprehension that he may be arrested next with the aforesaid FIR that has been lost by he submits that in view of the aforesaid, it should be protected by this court. By this. Full stop. Taking into account the aforesaid submissions. Before which police station?
My lord, not Guwahati police station.
Hmm?
Not Guwahati police station,
Not Gauhati police station.
lordship. And raid made by my lord Amingao police
You
outpost,
have made all of them parties,
lordship.
officer in charge, not Gauhati police station. In charge, Amingam police station of.
Amingao outpost.
Okay, in view of the aforesaid situation, the officer in charge of Gauhati police station shall submit a report for this court as to whether any FIR has been filed against the accused applicant, that is submitted before the non-Gauhati police station. the aforesaid report has to be submitted by the officer in charge of Gauhati Police Station by the next date fixed, that is on 8th of June. 8th of June.
My lord, no coercive action
No.
till then, my lord.
Absolutely not, Lordship, because the allegation is regarding misappropriation of fund, Lordship.
Sometimes, my lord, police first arrested, then registered, my lord. Till then, my lord, no coercive action, my lord, at least.
This has become a trend. I have seen this. This has become a trend. Without a FIR, you come because we do not know what is there in the FIR. You come and like you seek for some protection.
Obliged.
That protection cannot be given just like.
Obliged.
TP application, your lordship. FIR, it's page 8, your lordship. I'm not the FIR named person, your lordship. Main accused person has already been arrested and the stolen articles also has been recovered, your lordship. Page 15 is the forwarding report.
What have you stolen?
Some boring parts, your lordship. No, I am not the FIR named accused person.
You are not a partner in crime.
No, Lord.
Lordship, paragraph number 5.
And page 16, your lordship, the Jimma report already.
Mr. So-and-so, we are in function of the accused of. This called Mr. B. Sharma, the runner, this is in application. 42 of PNSS. 2023, praying for. Pre-arrest made. To the accused ticket in connection with Gauhati Police Station this time. In please book 2026 under section 305 bracket small a of BNS 2023. An FIR was lodged before the officer in charge of the police station on 27/1/2006, alleging that some unknown miscreants have stolen certain boring parts from godown of the informant situated at some crutch. All for the city need to make
Some protection, your lordship.
no.
May I please? This such case, my lord. The FIR is page 17, my lord.
Records may be called for, Lordship.
In that case, yes, I will one thing, my lord. The allegation is that, my lord, I have kidnapped this girl, my lord. He was recovered. Then, on the strength of this FIR, the family member of this informant, they have started demanding money, my lord. Then they were arrested, my lord. Both the cases were, my lord, charged. Thereafter,
Now, who are you? You are, charges have been framed against you?
no, my lord, it is notice has been served. Someone has been served for appearance, my lord. My problem is that, my lord, if I appear before the committing court, my lord, it is a session tribal, then I will be, my lord, in the custody, my lord. Another thing, my lord, your lordship will see
Allegation.
366, my lord, kidnapping, my lord.
Your name is there?
Oh, my name is there, my lord. The FIR is very, my lord, something different, my lord. Merely the impen FIR, my lord.
No. In the FIR, your name was there.
My name is there, my lord.
The Karsit, your name is there.
See, my name is there, my lord.
Why this court should grant bail?
But I will appear, my lord, face the trial, my lord.
We go there and appear.
Well, I went there, my lord, when approach the session court, my lord. Session court says that you surrender before the trial court, my lord. Yes, 37, my lord. Yes, 37. Considering the conduct of the accused, the pre-arrest bail application is rejected. Accused person Sakir Ahmed is directed to surrender before the learned trial court. Nowadays, my lord, it cannot be, my lord. This last Supreme Court judgment, my lord, the bail can be rejected, my lord. The in rejection, my lord, the court may not direct to surrender, my lord.
Before that, Lordship will kindly come to page 22.
But why he has been asked to surrender?
Lordship, for a moment, page 22. His anticipatory bail was pending, Lordship, and thereafter charge sheet was filed. That Lordship will find it at page 23.
22.
22 and 23 is the relevant portion. Lordship will find paragraph number 6, paragraph number 5. And paragraph number 6. Lordship has found it.
Yes.
Yes. Then Lordship will find this order at page 36.
This was passed on 1912.
Yes. Now Lordship will kindly come to page 36.
1912 2022.
Yes.
Then this order was passed on 742026.
Yes.
Yes, my lord.
Then
Earlier, my lord, I have a
No, Mr. Why? I mean, this order was passed in 2022.
this was this 1912-2025 order, my lord. Liberty was granted to approach the trial court, my lord. Thereafter, my lord, this summon trial court has issued the summons, my lord. If your lordship sees the summon, my lord, page 35. Summons to appear, my lord, before the committing court, my lord.
Hmm?
Before the committing court, my lord, this summon was issued, my lord.
Can you go and appear?
If I go there, my lord, I'll be, my lord. Because the FIR itself, your lordship sees, my lord, FIR itself is very, my lord, cryptic, my lord. See, my lord, my family members informed the informant that I have kidnapped their daughter, my lord. My lord. Yes, my lord. Charge sheet has been submitted, my lord. Your lordship,
In view of submission of the case, Ahmed Learned Counsel is submitted. The petitioner will approach learned jurisdictional trial court for seeking regular bail. But you have not approached.
before that, I have approached, my lord, I have kindly, my lord, page 4, my lord. Page 4, my lord.
Phase 4.
Page 4 of my bail application, my lord. It is authorized, not annexed, my lord, that upon apprehension of arrest in connection with Muradar PS case number so and so, the petitioner approached the court of the file a bail application before the court of the session Huzai. Same was rejected but order dated 2010-2022. Earlier, I have approached. Thereafter, I have approached the High Court, my lord.
Okay, we'll call for, we'll
records.
let us see what is there. What is his conduct summons, then maybe certain other things also. We don't know any bail warrant was issued. I mean, this non-bailable warrant was issued or not.
Next date is fixed on 12/8 for appearance, my lord.
Only summons has been issued.
Summons has been
Summons has
issued.
been issued.
No warrant has been issued.
How do you know that?
He has not mentioned that, Lordship, otherwise he would have mentioned it.
My lord, I have received one summon, my lord. That is, my lord, page 35, my lord. My lord, kindly protect me. I will appear before the trial court, my each and every date, my lord.
Lordship,
Because, my lord, both the cases were searched, my lord. My problem is that, my lord, page 37, my lord, the session court directed me to surrender, my lord.
When is the next day?
12/8, my lord.
12/8.
12/8.
Time is there. So we'll call for the records.
Yes, yeah. That will be on the basis of the materials on the case, the Lordship. Because Lordship, just a humble submission, Lordship. What is happening now, Lordship, is that when an FIR is lodged, the accused person, he avoids police arrest. He doesn't participate in the investigation. Subsequently, he is shown as absconder and charge sheet is filed. Thereafter, he comes with an anticipatory bail and pays for appearance before the court. So, Lordship, this will be the trend, Lordship.
That is why
Yes.
I'm asking that
If,
let the records come.
yes.
Let us see how what was his conduct.
Yes.
Till that time.
That conduct will find it at page 36 itself, Lordship. The trial court has mentioned that, Lordship. Page 36, if Lordship kindly sees the last paragraph in 36, Annexure 7. After perusing the case diary, we observe that there are two house search memo in which 2-3 independent witnesses are there. House searches were conducted on 17-10-22, 25-9-22. The case has been charge sheeted under section 366 of IPC. Charge sheet was filed under 360 IPC, showing the accused as absconder. Now the case is ready for appearance, committal and trial. So Lordship, if he is not present during the investigation, there has to be some valid reason.
My lord, if my learned friend is submitting on a merit, my lord, may I point to one thing, my lord?
No, nothing doing.
This, my lord, direction part, my lord.
What?
This direction part, my lord, direction.
There's a lot of time. We'll see.
Yes, my lord,
we'll
yes,
see
my
the
lord.
record. We'll see.
But it is signed out to before.
Mr. Your name?
TK Bhuya, my lord.
TK Bhuya.
My lord.
TK Bhuya, the learned counsel according to the accused and first to her Sadish Sharma Gavan for the state. This is an application of section 482 BNSS. Here is bail to the accused convicted in connection with Murajhar, PS case number 1/202, registered under section 366. An FIR was lodged on 11/9/02. Got a main accused,
So like this.
alleging that the informant's daughter was taken away by the accused, eluding her, and thereafter committed rape on her. Committed rape on her. On receipt of the affair, the police registered Murajar PS list number 221-2022 under section 366 IPC. The charge sheet in the inside case has already been. Is there any record when it was filed?
Sarsi, there I have annex, my lord.
Charge sheet in the inside case has already been submitted on
Page 24, my lord, 29/10/2022.
29/10/2022. White charge sheet number
Sarsi number 192/22.
192 raised to call for the PCF in connection with Murajar case number 222-21/2022. From which court?
My lord, CJM Huzai.
CJM Huzai, from the Chief Judicial Magistrate Huzai. Let the matter be fixed on 9th.
Ninth Lordship, it won't come also.
10th, my lord.
Because it will come from the register, it takes time Lordship.
Then let it be on 18th.
18th.
18th June. You have sufficient time.
My lord.
May I please Lordship? Charge sheet submitted Lordship. Charge sheet submitted Lordship.
Two cases, Lordship. My lord, in two cases, Lordship. One is my Dorgao, my lord, 41, other is my 42, Lordship.
Name.
My lord, I am for bail in my lord, Dorgao 41, Lordship.
1064.
Lordship.
Huh.
My lord, this is Dolgao PS 41 of 2026.
41 Lordship, CD not received them.
In today for 81 days, my lord, one is 81 days, another 76 days is judicial custody, Lordship.
20 days when.
My lord, 90 days is there, Lordship. Now,
No, the CD was sent back for updation Lordship, earlier occasion. It was there, then it was sent for updation Lordship.
in the cross case, Lordship, in the cross case, charge sheet, my lord, 47 probably charge sheet is filed, submitted, Lordship. My lord, in the cross case, probably charge sheet has been submitted, Lordship.
Yes, cross case charge sheet has been filed.
It's filed.
But Lordship, this is a case of murder. 103 is there Lordship. Please.
Lord, a group fight is, my lord, group fight is, was there between my lord plaintiff and defendants, Lordship. The petition number 2 is the, my lord, son of the plaintiff, Lordship. And as regards, my lord,
Report from the aims was required.
Yes. So Lordship will fix a date, short date, Lordship will produce the case then. Because this is a case of murder Lordship.
tomorrow or day after tomorrow, my lord, maybe. Already report.
Tomorrow it will not be possible.
Day after tomorrow, Lordship. Already
Let it be on
report
8th Lordship.
The 8, let us be to fix on 8. Yes. It will not come, otherwise what is the point of listing? It doesn't come. Because that will be required. Is that will be. Mr.
May chance.
Ahmed, the learned counsel, brings for the appearing for the accused applicant. How many are there? How many are there? One.
My lord,
Two
petitioners, two petitioners are there.
Accused applicants. Also heard Mr. D.P. Kuskar. Also heard Mr. B. Sharma, the running APT for the state. Mr.
I'm for informant.
Mr. Your M. Ali for respondent number 2. For respondent number 2 in comma informant.
There is no respondent, my lord. I myself has filed vocal.
Huh?
I have not made party,
Oh, you have not paid.
No. but I have filed Ukalatnama for informant.
You can write only informant. Don't write respondent, only write informant. Informant. And Mr. Sharma submits that the case diary, updated case diary, updated case diary along with Ames report is not available. He prays for some accommodation. Let the matter be fixed on 8th of June. 8th of June.
Lordship, before that, this week, if possible, Lordship, my lord,
No,
a long time he's in.
Yeah, I mean, this is a case of murder
Lordship, that is.
and court has to look into the case diary. If I fix it also, it will not come. What purpose it will serve? You wait for a couple of days. Today is Tuesday. Next Monday, we are fixing it.
Oblige, Lordship.
And this is a bail application, right?
Lordship.
Wait for some.
May it pleases your lordship. Your lordship, this is a regular bail application. As the petitioner is in custody, the FIR is at page number 28. May I read? I most respectfully state that my sister, namely Shruti Roy, has been married to Rupak Sen, son of Sunil Sen, resident of Lal Ganesh, Vivekananda Path, house number 102, PO Udal Bakra since last 3 months. Today on 26/4/2026 at 11 a.m., her husband informed my father that owing to ill health, she has been admitted to Marwari hospitals. I, along with my family, went to the aforesaid hospital and found that she has been admitted to the ICU. In the evening at 5:25 p.m., we have been informed that my sister has died. Sir, we could not know what had happened to my sister and how my sister died. So I pray before your good shall to investigate the death of my sister.
Yes, yes.
Necessary actions. So on the basis of this,
From marriage.
3 months.
3 months of marriage. So on the basis of this, actually the victim has already been suffering from diabetes and other ailments. So
What
on
ailments?
other ailments, and the report also reveals like 200 at page number 48, the medical reports. So on 23, 48. On 23, they went to a doctor, they visited a doctor, the doctor advised
The documents 48 you are saying, right?
48, page number 48.
What is that biological?
That is the Department of Biochemistry, this
Square is 270.
217.
Then what is that?
GPT 417, this is also high, SGPT,
Bit high.
bit high.
Then
Then other things are potassium and albumin are,
these are what are the ailments?
these are the,
I'm also diabetic. 217 random is nothing. Then what else?
these are the ailments, and she was undergoing treatment. On 26, she was admitted.
What else? Diabetes, and what other ailments?
Diabetes was the main ailment.
Person can die. By having random blood sugar 217
No,
of diabetes.
That is,
Somebody die.
that is not the submission.
It's for last 50 years.
That is not the submission. My lord,
Then that's why I'm asking you, what else?
the other ailments were there and she was undergoing treatment.
Other ailments, you'll have to tell us. No? Otherwise, how? I mean, so you see, somebody after within 3 months of her marriage, she died
She died
in a hospital.
in a hospital.
Suddenly, right?
Suddenly.
And you are saying that she must have had some ailments.
Ailment.
Now you'll have to tell me what are the ailments. Then court will see whether those ailments can be cause of her death. And if those are not cause of her death, then there will be maybe certain other reasons. So we'll have to evaluate the things, correct? So you'll have to
Correct.
tell the facts to me. So you tell me what is the other things.
Apparently, she was finding difficulty in, she was having tummy pain and other pains and also having some arthritis problem. And they went to the doctor and the doctor examined her and asked her to get admitted on 26/4. Then 26/4, her condition deteriorated. She was admitted to ICU and after
So that's why, I mean, discharge summary is there.
discharge summary is there. It is at NHF 10, page number 59.
Is number
59. That is the medical certificate of cause of death.
59.
59.
Is there any postmortem report?
Yes, Lordship.
Postmortem
I was
was
coming
called
to that,
for.
Lordship. PM has been done. And Lordship, now the final opinion has been kept pending, Lordship, because the hospital suspect it to be a case of poisoning, Lordship. That is why that report is still awaited, the FSL report. Because when it was treated, the hospital has issued this certificate, MLC certificate, Lordship. Lordship will kindly see this document. So until the FSL report is before your Lordship, it will be difficult to say, Lordship, how she died, because she was a healthy.
No, this, I mean, see, I mean, discharge summary is itself, so.
Yes,
Acute
cardiac.
liver injury. Hypoglycemia.
Hypoglycemia.
Acute renal injury.
Yes.
Dyspasis, all these things cannot happen together just like that. Liver injury, hypoglycemia, then acute renal injury, all these things cannot happen.
Yes. All of a sudden, it doesn't happen.
It cannot happen like that. There has to, there has to be something, some more, more investigation is required to be gone into.
Lordship is already 35 days he is in custody.
Good.
And moreover, the submission is that these are medical documents, technical documents, they will.
So we, Mr. Sharma, we wait for this, has it
yes.
been called for?
Yes, already I have intimated the IO also. The IO has sought some time, Lordship, because FSL report, Lordship, till that FSL report is received, it will be difficult to say, Lordship, what has happened.
FSL report is coming.
It is awaited, Lordship.
It's awaited.
It is awaited.
We'll post it some other time.
Short date will be taken. That is my point.
Heard Mr.
AI Ahmed.
Yeah, I made the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the allied Mr. B. Sharma, the allied APP state submits that FSL report, FSL report monitoring the death of the victim, it shall be necessary in the instant, case, and the same has already been called for. However, the same is yet to be received. Let the matter be listed.
Lordship, let it be on 15th.
15.
Shorter date if possible.
Lordship, it takes time.
Mr. What is the point?
Deeply obliged.
Let it come, then we'll see what is there.
May it pleases your lordship.
CD not received, Lordship.
Hmm?
CD not received, Lordship.
CD is awaited. Let the matter be listed on.
Lordship, as per your Lordship's convenience,
1 week, lordship.
10, 11, 12.
11th to June.
Deeply obliged.
Yes, there is come.
No, Lordship, petitioner is on interim. Oh, Lordship, here what has happened, Lordship? Originally, the case was filed in Rauta, Lordship. Thereafter, Lordship, to my instruction, it has been transferred to Gauhati, Lordship, some dispute. So, Lordship, that communication is still awaited. Petitioner is away, on interim, Lordship. A date may be fixed, Lordship.
Okay, none appeared for the petitioner, none appeared for the accused applicant where the matter was called for. Though Mr. B. Sharma, the learned APP is present. Let the matter be listed on 18th
18th.
June. CDS,
CDs come, Lordship.
we will take it up for some time.
Here also, Lordship, petitioner is on interim and CD has not been received.
CD not received.
CD not received, Lordship.
CD is awaited. Mr. So and so is present for the accused applicant as well as Mr. B. Sharma. So and so. Let the matter be listed on
19, Lordship. 16, Lordship.
16. Yes, there is come.
No, Lordship. One report was called for, Lordship. কি লিখলাম?
None appears with none appears with the accused applicant when the matter was called for. CD is awaited. Let the matter be listed on 11 June. 11 June.
May it please your lordship.
He also
Lordship, we perhaps has not.
Petitioner going interim CD has not been received, Lordship.
Mr. So-and-so is present for the accused applicant and Mr. B. Sharma is for APP. Case that is not received, let the matter be listed on, listed from 11th June. Interim orders of past areas and continue to the next list. Yeah.
Lordship, 19 June if possible. 19 June if possible, Lordship.
We fixed on 11 June.
11 June. Okay. Deeply obliged.
He also, Lordship, CD not received. Interim is there, Lordship.
Yes, and go with
CD.
then for the accused applicant. So B. Sharma is for so-and-so. Then CD not received, let the matter be listed on 12th June. Then
Interim order,
orders of past areas will continue to the next list.
interim order is done. I let you.
Tacit submitted, Lordship.
It's already interim mail.
Charge sheet has been submitted, you go and appear. Okay, heard MSP Bora, the learned counsel for the accused applicant, also heard Mr. B. Sharma, the learned APP for the state. These an application are according to BNSS, 2023, being told a pre-arrest bail in connection with Tinsukia PSP's number 10/026 under sections 75 to 79 to 3 in bracket 5 of BNS 2023. It is submitted by the learned APP that charge sheet in the instant case has already been filed by charge sheet number
50/26 dated 20/04/26.
In view of the aforesaid. The instant PV application is disposed of with a direction to the accused applicant to appear before which court?
CJM Tinsukia.
CJM Tinsukia. Before CJM Tinsukia within a period of 10 days of passing of this order. Till such appearance of the accused applicant. But the interim order so passed earlier. In terms of the opposite direction, the instant PV application is
Obliged.
Here also, Lordship, Chassis submitted.
But Mr. So-and-so, the learned counsel, appearing for the accused applicant, also have. Your beat collector.
No, Your Honor, I'm S.J. Chaudhary. My
I think-
senior is on the way here.
So, and also heard Mr. B. Sharma, the learned ABD for the state. This is an application under section 3 of BNSS. For two of BNSS. Praying for granting PRS bail to the accused applicant in connection with Sipajar police station case number 2026 registered under sections 118 in the 296 of BNS. The learned APP, Mr. B. Sharma, the learned APP submits the instance. The charge sheet has already been filed by charge sheet number
53/26. Lordship, the date is not before us. Date is not there. Date is not.
Okay, by charge sheet number so and so, so and so. So and so, yeah, before which court, any idea?
No, Lordship.
Before the jurisdictional court, before the jurisdictional court. Full stop. In view of the opposite, the instance of the AB application is disposed of with the direction to the accused applicant to appear before the jurisdictional court within 10 days of passing of this order, and the interim order so passed earlier shall continue till his appearance before the jurisdictional court. in terms of the aforesaid direction, the instant is.
28 and 30 Lordship of the same FIR Lordship.
Up to date case was called for, my lord, probably it is there, my lord. Already, my lord, considerable, my lord, investigation is progress, my lord, that there are already 9 person who has, my lord, named by the witnesses have already been arrested. So whether is there any, my lord, material against me, my lord?
It's a group class, Mr. V. Sharma, there's a group class and a lot of people put the sides.
Yes,
Got injured and someone died also.
2%.
Now, if there is something in the CD about these 3 persons, specifically Akel Ali, Mahmoudul Haq and Abu Said.
It is there.
Huh?
If they are, my lord, I am, I'll leave it to your lordship.
Let us see.
Fine.
What is that?
Immediate question.
Lordship, there are witnesses, a number of witnesses are there. There 183 has been recorded.
Now, see, I mean, just point out those, I mean, just flag mark those and give it to me. I
Yes,
mean,
yes.
wherein, I mean, some
These 3 person.
specific allegations are there against.
Lordship. These statements are one after another, Lordship. This is just the 183 Lordship, and there are other witnesses also.
Mr. Sharma, as far as these three person are concerned, did you find anything? I didn't find it.
Is there, Lordship?
You find out.
Yes, Amjad Ali. You didn't mention that.
I am not giving
He is not Amjad Ali. He's
Oh, I'm sorry, Lordship.
the
Amjad Ali. is-
other three persons. Akhil Ali, Mahmudul Haq,
Yes.
and Abu Said. Just find out if something is there.
Then, Lordship, may I suggest after a few minutes, Lordship, in the meantime, I'll just
No problem.
click on the.
Let him go through it.
My lord,
Not
I'll
a
not
few.
be there, my lord, in my family, I have one.
No, no.
If time, I'll come back.
We'll see. Like, I
My
mean,
lord,
if-
my
if
lord,
there
I
are
leave
some-
it to your lord. If anybody says my name, my lord, definitely my proof person still here, my lord. This is a good.
If there are some materials, then
My lord.
we'll see. We'll
My lord.
consider. Mr. Doctor, you also have.
I mean 30, my lord. If he has referred Amjad Ali, my lord. In my case is there, my lord, there is
They will take it up together. Let him go.
only that point he has to look. My lord, that-
Let him verify. You are saying that two Amjad Alis are
Yes,
there,
my
right?
lord.
He's saying two Amjad Ali, Mr. Sharma. Yeah, you have some hurdles.
Yes, Lordship.
You have to go through it properly. He said DP. Just read those
Lordship, after some time.
after some.
Yes, Amjad Ali.
Maybe, Lordship. A report was called for, Lordship. That report has not been received.
What was the report?
What about Lordship? The thing is that one suicide was committed, and on apprehension, I have filed an anticipatory bail, Lordship. And regarding any registration of case or not, a report.
Okay, they're regarding the registration of case.
Yes.
Again.
We'll get that report, Lordship.
Hmm?
I will get that report, Lordship.
Okay, heard Mr. A.K. Sharma, the learned counsel appearing for the accused applicant, also heard Mr. V. Sharma, learned APP for the state. Instant AB application has been filed with the apprehension of his apprehension of being arrested by the accused applicant. However, the same has been filed without any details of any complaint or FIR. In view of the aforesaid, a report was called from the concerned police station. However, the same is yet to be received. Let the matter be listed on when?
8.
On 8th of June.
Here, Lordship, again, Lordship, that report was called for, it has not been received.
Again on without any this thing.
Yes,
This has become a trend.
yes.
Hmm?
That is the difficulty, Lordship. It's from Dispur, Lordship, I'll get that report.
Okay, heard Mr.
Jay Abbas.
J. Abbas, the learned counsel, appearing for the accused applicant, also heard Mr. B. Sharma and APP for the state. One GD entry was there. Mr. Sharma.
Yes. In the earlier case.
Hmm?
In the,
This case, the GD entry is there. Accordingly, GD entry is also made, but till date complaint is not registered. Some report you have received
Oh, yes,
already.
on the last occasion, our report was received,
Hmm,
Lordship.
hmm.
If I remember correctly, Lordship, one inquiry was done, Lordship, but case was not registered probably.
Hmm.
So again, I will have to take that report, Lordship.
The anticipatory, the instant anticipatory bail application was filed with apprehension of being arrested. However, no, no details of any complaint or FIR was provided while filing the application, the instant application. Accordingly, a report from the concerned police station, that is Fatasil Ambari Police Station, was called for. Though a report was received earlier, but uh, is without all the details. Therefore, therefore a detailed report was again called for, which is yet to be received. Let the matter be listed from 8th of June.
If Lordship permits me, can I have a copy of that report, Lordship, for communication?
The report is not there, only this thing is there.
Oh,
There is an order, it has been noted.
order, Lordship,
If you see this order to
Lordship,
5,
Lordship.
then there is a mention of the report. Oh, no, wait. There is a report, wait. Once again, let me see. Yes, it is there. What is your name?
Muhammad Sahil Khan.
Mohammed
Sahil Khan.
Sahil Khan.
Yes.
On 9/4/2026, complaining mainly criminal laws, written complaint that common pains of the Sahil Khan and public health, especially in hospital. The written complaint is filed already. Written complaint on 9th April 2026
Yes.
has been filed against him.
But
And
Lordship,
an inquiry has been done also to arrest him. You can have a look of this.
yes, Lordship, I'll just take a look.
I think there are sufficient materials against him.
Yes. Yes. Yes, Lordship. GD entry. It is there, Lordship.
And like there are materials against him.
Yes, there are material against him, Lordship. Yes.
Inquiry has been done.
Yes.
They are trying to arrest him.
Yes.
CD is required to be called for.
Lordship. We'll call for the CD then, Lordship.
No, I don't think we need CD. I mean, this inquiry report is sufficient. I'm not inclined to give him any bail.
Let them come with the proper documents, Lordship, FIR copy and all. They can go and apply a bail also in the concerned court.
No, I mean,
FIR has to be registered.
it is keeping this pending.
Lordship.
Hmm?
Lordship.
What is the point of keeping this pending?
No point,
There
Lordship.
is no point keeping this
No point,
pending.
Lordship.
You forgo,
FIR has not been registered yet.
Huh?
FIR has to be registered yet.
the complaint has been filed, it has been stated.
On his identity is there, but FIR has not been registered.
Huh?
FIR has not been registered yet.
Lordship,
Stated that complaint has been filed on 9th April
9th
2026.
April, yes,
Huh. And registered a GD entry already.
only.
GD entry is already there, but what else more you want at this case? Okay, right, heard Mr. J. Abbasi, the learned counsel, appearing for the accused applicant, also heard Mr. B. Sharma, the learned AP for the state. This is an application under section 482 of GNSS, praying for bail on anticipation of registration of a case in Pakawasel Ambadi jurisdiction against accused. Since there was no complaint or FIR, there was no details of since there was no complaint, no details of any FIR or complaint have been provided in the instant application. A report was all from the concerned OC of Potassium Ambari Police Station by this court. Full stop. A report dated 11/5/2026 of ASI, Profulla Gogoi, Potassium Ambari PS, Gauhati Waste District. Has been received by this court. Dated 11/5, dated report dated 11/5, has been received from the received from the AP by this court. The report reveals that on 9/4/2026, a complaint was lodged by one Srimati Moromi Rava against the accused applicant and his bodyguards, alleging that the accused applicant along with his bodyguards forcibly entered their residence and assaulted her and her husband. It was also alleged that one tenant of the informant, namely Raja Baskov, was also assaulted. It was also alleged that the accused applicant and his associates touched her in a wrong manner to outrage her modesty. The report reveals that a GDE was made by Potassium Ambari PS GDE number 10 dated 10/4/2026. It is also revealed in the report that the place of occurrence was visited by the police and in terms of the investigation, there are sufficient materials against the accused applicant about his involvement in the alleged offense as made in the complaint by the informant also. Taking into account the report which is kept on the file marking X. This court is of the considered opinion that that the that that the privilege of anticipatory bail cannot be granted to the accused applicant at this case. Accordingly, the instant AB application is dismissed.
Bless.
I'll just come back in 5 minutes.
Lordship.
Fair page 9 type copy lordship. Vernacular page 13. CD was one for lordship. The lordship, one minor daughter committed suicide lordship, one minor girl. Where the relatives of them in common lordship. Page 9 is the type copy of them.
Here also, lordship, the FSL report is pending. That will be required, lordship. Because murder has been incorporated in the FIR, lordship. There are murder is there, lordship. Murder section is there. And the investigation in respect of the FSL report is still awaited, lordship, because the final opinion of the death has not yet been ascertained, lordship. That can be ascertained only after the FSL report, lordship.
Okay. Heard Mr. A.K. Ahmed, the government counsel appearing for the accused of missing. So heard Mr. B. Sharma, for the state. Mr. Sharma submits that case diary in the instant case along with the FSL report is yet to be received. Later matter will be listed on
Lordship,
11th.
but
11th we have fixed already. Like
if many cases are fixed.
Hmm?
15th?
15th.
We are not interim lordship. We are not interim.
Make it on 10th then 10th. 10th possible.
The FSL report won't come, lordship. Takes time. Yes, 15, lordship.
We'll keep it on 15.
15.
Let the matrix on 15.
May I taken after some time and let Mr. HRS will appear in this case.
So here's a simple case, lordship. Lithium batteries from the towers are being stolen. And 3 persons have already been arrested. They sold it to the present petitioner, who is a owner of a electronic shop where he sells batteries and all those kind of things. Now, lordship, those batteries, lordship, it appears to be very small, but the cost of one lithium battery is around 1 lakh.
And those are stolen from?
From towers, lordship. That is the allegation against him.
And
Otherwise, lordship, he was on interim, he has appeared. And he has stated that yes, those persons came to me and sold to me. Now,
batteries only.
Wait, let it submit.
those batteries were sold to me, around 3 batteries were sold to me. And those have not been recovered as of yet. So that is the.
So let him go, then he is let him participate.
Lordship.
I heard Mr. M. Ahmed, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 482 of DNSS 2023, praying for granting PRS bail to the accused applicant in connection with almost PS case number 34/2026 under section 303 in bracket 2/317 bracket 2/3 bracket 5 of DNS 2023. An FIR was lost. Where is the FIR?
Page 11.
An FIR was lost by one Sahiful Ali on 17/4/2026. Alleging that Indus Tower, wherein the informant works, has a mobile tower at Nice, Tabaka, opposite Warnoble College. And on 15/4/2026, some unknown persons stolen had stolen 10 numbers of lithium battery. Full stop. On receipt of the affair, the police registered police registered Salvo police station case number 34/2026 under the aforementioned sections. Full stop. This code by order dated 6/5/2026 granted interim relief. Granted interim pre-arrest bail the accused applicant. Full stop. Is submitted by the learned counsel appearing for the petitioner, appearing for the accused applicant, that the accused applicant has already appeared before the police and confessed his guilt. Confessed his guilt.
No, see, actually, I'm not one Mukta, but he has come to the
You bought it that you have stated, no?
only two batteries.
Confessed,
Immediately.
confessed his guilt. Full stop. CD in the instant case has already been received and the same is perused. Full stop. Taking into account the fact that the accused applicant has already appeared before the police and got his statements recorded and also fully cooperating with the investigation. This court is of the consent of the considered document. Interim bail. So interim FPRS bill. So granted accused applicant should be made absolutely according the interim pre-arrest bail granted on 6/5/2026 is made absolute on the same terms and conditions as provided in the order dated 6/5/2026. In terms of the official direction that the instant AV application is disposed.
Did you receive lordship? Is a case of promise to Modi.
Petitioner appears before IO. His statement has been recorded. Our FIR is Karnataka space 15. That's the copies, my lord, page. My lord.
Yes, Mr. Ahmed.
Hello, the petitioner, wherein he is a student of Assam Science and Technology University, 8th semester student. And the informant, she is a married wife and not a divorcee, madam. She also filed a case against her husband, a DP case. She is getting maintenance. She is living in Lotus Lambar area. I have no connection with him, her, my lord. And their marriage is not yet terminated, my lord. So my statement has been recorded. You'll also kindly see my statement made both IO. If you'll also kindly see the page 17, she also filed a DP case against her husband. 30 years old lady, my lord, married wife. I am a student, my lord. She tried to blackmailing me, my lord.
Why she will blackmail you?
Because, my lord, she's living here, my lord.
There has to be some reason, otherwise why
Because my statement has been recorded. Absolutely false allegations, my lord. Absolutely false allegations. my lord.
False allegations, why you have been chosen out from, I mean, this is a country of some millions. Out of so many people, why he has chosen you?
They have no such relations, but she is also living in that area. Sometimes she meet her in a market. So I am a 8th semester student, my lord. Assam Science and Technology University. My examination is going on, and last examination will be held on 11/6/2026.
11/6,
11/6/2026. Examination is going on.
examination is going on.
Going on, my lord. So, my lord, my statement has been, I cooperate with the investigation, my lord. Lordship may kindly. No date has been mentioned when, no date, specific date has been mentioned. When she come with my residence, when I committed her rape. Nothing is there in the file, my lord.
I'm allowing this. She's a measure, she's a married lady. Heard Mr. J. Ahmed, the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, the learned AP speak.
Thank you.
And this is an application under section 482 of BNSS for granting PRS bail to the accused applicant in connection with Kauchuk PS case number 68/2026 under section 69 of BNS. Full stop. An FIR was lodged on. Where is the FIR?
Page 10, my lord.
An FIR was lodged on on
3/4/2026.
3/4
2026.
3/4/2026 by the informant alleging that the accused applicant got acquainted with her for about 2-3 months and with the promise of marrying her, he had taken her to his rented house and committed rape on her on many occasions. Full stop. It was alleged that due to the aforesaid physical relation, the informant got pregnant, and when she requested the accused applicant to marry her, he, along with his family members, refused to marry her. On receipt of the FIR, the police registered Gauhati Police Station case number 68/2026. Mr. J. Ahmed, the learned counsel appearing for the accused applicant, submits that the accused applicant is a student of Assam Science and Technology University, alia. Whereas the informant is a married woman, is about 34 years. He further submits that the accused applicant is taking his 8th semester at present, and the next examination is scheduled on 11/6.
11/6.
11/6/2026. This code by its order dated 6/5/2026 has granted interim pre-arrest bail to the accused applicant. Stop. Is there in the instant case has been received and the same is perused. The learned counsel appearing for the accused applicant submits that in terms of the order dated 6/5/2026, the accused applicant has already appeared before the investigating officer and got his statement recorded. Therefore, he submits that at present, since the accused applicant is undergoing his examination, no examination, his custodial detention in the instant case may not be required. This court has heard the submissions made by the counsel appearing for the respective parties, has also produced the case diary, taking into account the materials available in the case diary, as well as submissions made by the respective parties, is of the considered view that the interim order so passed earlier should be made absolute. Accordingly, the interim pre-arrest bail granted to accused applicant on 6/5/2026 is made absolute. In terms of appropriate direction, the instant AB application is disposed of. CD to be sent.
Item 20.
Yes, the idea has come. 20. Item 20. Who is there? Who is there in item 20? None appeared for the petition, none appeared for the accused applicant when the matter was called for. So Mr. B. Sharma, the learned APP, is present for the state. Is that in the instant case has been received? Let the matter be listed on on 4th June.
Yeah, Lordship, in respect of Akel Ali and the two others, Lordship, their names have not, is not there.
Is there?
And Lordship, in regard to Amjad Ali also, Lordship, there are one more Amjad Ali is there. And I have found two witness, Lordship. They have stated that this Amjad Ali, son of so-and-so, this present, he was not present in the day of occurrence. That is a statement of one of the witness, Lordship.
So we'll allow them.
Lordship.
I've seen that also.
Yes.
Heard Mr. P.J. Mohanta, the learned senior counsel, assisted by Mr. R. Ali.
AM Khani.
A.M. Khan, the learned counsel appearing for the accused applicants. Also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 482 of BNSS, 2028 for releasing for paying for the arrest bail to the accused applicants in connection with Sunari PS case number. Sunari PS case number 5/2025 under sections 189 bracket 4 stroke 190 stroke 191 bracket 2 stroke 117 bracket 2 stroke 109 stroke 118 bracket 2 stroke 103 bracket 1 of BNS 203. The allegations as reflected in the FIR that on 13/9/2025, one Ghulam Usmani, a resident of village Istomoni Talk, had lost lost an FIR at Chunari police station, alleging that on 12/9/2025 at about 6:30 p.m. some persons, namely Anwar Hussain, Bandes Ali, Mainuddin, Nuruddin, Atab Ali, Sahar Ali, Duran Ali, and Suhab Ali went to cultivate black lentils, the village Lokhoa, RBNC, Part 4, in an area of 20 acres of land. And when they were cultivating, the accused persons, equipped with deadly weapons like lathis, rods, dows, swords, and other sharp weapons, went to the place and attacked them, causing grievous injuries. All the above named, all injuries to the above named persons. two persons, namely Manwar Hussain and Abdul Sattar, alias Sattar Ali, got seriously injured, and when they were taken to Lakhimpur Hospital in critical condition, they were declared brought dead. Full stop. On receipt of the FIR, the police registered Chunari PS case number 5005 under the aforementioned sections. Can you write? Can you write, Mr. M.A. Khan?
Yeah, Khan.
I'll write his name or your?
Yes.
Mr.
DJ Mohanto.
Huh?
DJ Mohanto.
Mr. Mahanto, the learned counsel, is doing for the accused applicant. Accused applicants submit that the accused applicants are no way linked to the aforesaid incidents that has been narrated in the FIR. He submits that though there was a group class, the accused applicants were not present in the class, and their names may have been cropped up because they belong to the same village. He submits that the accused applicants, if required, will fully cooperate with the investigation, and therefore, at this case, the accused applicants should be granted the privilege of pre-arrest bail. Case diary in the incident case has been produced, and the same has been produced by this court. The Mr. V. Sharma, the learned APP, however, opposes the bail application, opposes the prayer of anticipatory bail, the accused applicants, stating that that two persons have been brutally killed during the group aforesaid. After taking into account the materials available before this court and including the statements of witnesses, this court is of the considered opinion that the accused applicants should be granted pre-arrest bail this case. Accordingly, it is direct that in the event of arrest of the accused applicants, the arresting authority in the event of arrest of the accused applicants in connection with Chunari PS case number 5/2025, the accused applicants shall be released on bail, release of bail, on furnishing of bail bond of ₹30,000 each with security of like nature to the satisfaction of the arresting authority, subject to the following conditions. Number one, that the accused applicants shall appear before the investigating officer within a period of 10 days of passing of this order. Number two, the accused applicants shall cooperate with the investigation and make themselves available as and when called for by the investigating officer. Number three, the accused applicant shall not try to influence or dissuade any of the witnesses connected to the incident case. In terms of the aforesaid, the instant AB application is disposed of. Next, we same,
Alright.
just write NJ, NJ doctor. So everything is same.
Everything is
same FIR.
Only same FIR, same my lord. Only my submission will be my lord, page 4, paragraph 6.
Page 4, paragraph 6.
There it is written bakes to
Other this application. Page 4. 1 second. Then he can replace Mr. Dutta submits that. Mr. NJ Dutta submits that.
paragraph 6.
submits that though the name of one Ahmed Ali, what is his name? Amjad Ali.
Amjad Ali.
Amjad Ali has has been taken by some of the witnesses. The aforesaid Amjad Ali is a different person, and the present applicant was not present when the aforesaid group class occurred. On which date was this? On 12/9/2025. He submits that in fact that the accused applicant was present. Where he was?
I was present in Tilapara market,
He was present in Tilapara market,
which is about 20 kilometers
which is
away.
about 20 kilometers away from the place wherein the group place occurred. Yes.
I'm obliged.
Understand,
Yeah, my lord, my name, my lord, son of my lord, that will be required.
So normally, no, I'm the
Son of.
accused applicant, son of prosecutor. That will put,
Mine.
doesn't matter.
The other Amjad Ali is there, but that's. I'm obliged. my
But no, this, the present accused applicant is son of so and so. But वो वाला जिसका नाम आया है अमजद अली, there is somebody else. उसे बना कर देना। We have just posted it for to get the records.
Yes.
Lordship, the records will came in the morning, but however, we are informed it will be taken up at 2. So they when back they'll come back at 2, Lordship. So we'll pray because it was informed to us by the court master.
Lordship, I'm seeking your Lordship's indulgence. I understand that the hearing is over. What fell from your Lordship is why we wrote on paragraph 4 of our petition that we've submitted the OHSAS certificate. Lordship will indulge me 5 minutes to clarify that.
That I understood because I mean because see this is while looking into the documents we found out that the document was in fact OSSA's.
Yes, yes.
I mean but thing is that like you are saying that like, it has become obsolete, so you have that document.
No, Lordship, what actually is the situation is this. It's always called either OHSAS or ISO. There is no OHMSS. That is what we've discovered. If you look at the certificate,
document therein is a different document.
No, your Lordship, that is what we wanted to place. Would you hear us now or at 2 o'clock?
No, we'll take it up at 2 o'clock.
2 o'clock. 2 o'clock. Yes, please clarify.
Wait. How about 2 o'clock will take.
Obliged, your Lordship.
Really obliged. Lordship.
Yeah, some will have to be there.
Who will appear in this matter? Mr. Bokolia.
Oh, your Lordship, Senior GA appears in this case, your Lordship. Your Lordship may fix it in some other day, your Lordship. Showing his name, your Lordship.
Senior government advocate. Did not appears. Okay, then we'll fix it up some other date.
Lordship.
Or some other day. Mr. S. Botakur, the learned senior counsel, assisted by so and so, is present for the petitioner. However, none appeared for the government. None appeared for the state respondents when the matter was called for. Let the matter be listed on. When do you want Mr. Botakur?
Lordship, for 14th, your Lordship. 14th of July.
14th of July. Why so late?
Then, your Lordship, on 23rd, your Lordship.
This is a case of what?
For consolidation of the affairs, your Lordship.
Okay, 23rd of June.
Lordship. Deeply obliged.
May I please, your lordship? Lordship, my senior BM Chaudhary is not keeping a good health, lordship. Is not keeping a good health, lordship. Lordship, can it be taken on some other day, lordship?
When do you want?
Lordship, any day, lordship, after 2 weeks, any day, lordship.
After 2 weeks. Mr. E. Chaudhary, the learned counsel, appearing for the petition, submits that Mr. B.M. Chaudhary, the learned conducting counsel, is unable to appear in the matter today. He prays for adjournment of the matter for 2 weeks, which is not opposed by the learned counsel appearing for the state respondent. Let the matter be listed after 2 weeks.
Oblige, your lordship.
Lordship, my senior is coming.
Hmm?
My senior is coming, Lordship.
Who is your senior?
M. Khan. M. Khan.
Where is your senior?
You know, Mr. Court's Lordship is coming.
He is roaming in the corridor,
No,
walking in the corridor. What? M. Khan, where is M. Khan? Okay, we'll pass it over time. Point of view. None appeared for the petitioner, none appeared for the appellant when the matter was called for. However, Mr. D.P. Goswami, the learned APP, is present for the state respondents. Mr. P. Das, the learned amicus, appointed to assist this court, is also not present while the matter was called for. For interest of justice, let the matter be fixed after 2 weeks.
Matter will pass over for a time being. My senior IH Shaker is on port number 7. IH Shaker sir is on port number 7.
Okay, time being. None appeared for the petitioner. None appeared for the petitioner when the matter was called for. Let the matter be listed after 2 weeks. Weeks.
The side is also easier. So
1 second, we'll just take some clarifications.
Yeah, just a moment.
Okay, let us see that.
Lordship, may I just submit?
You just let us go to that requirement first.
Yes, page 44, Your Lordship, of the big document.
Yes, bid document.
Yes, Your Lordship.
Page.
Page 44. Number 3. B3.
Yes, who is this?
Safety qualification criteria for bidders.
And what is your pleading?
My pleading is paragraph 4, which was a problem that was pointed out.
Yes.
that it was mentioned therein that the last date of submission of bid was 15/9/25, after which the technical proposal was opened and evaluated. The petitioner submitted all the relevant documents, including its occupational health and safety system OHSAS certification.
Correct.
However, what transpired was that inadvertently an expired OHSAS certificate. So it was pointed out that this should not have happened. We should have said OHSMS, which is why Your Lordship may kindly take a look at the bundle that I have right now.
No, the document that you have submitted with
The wrong document, expired document, is at page 79, Your Lordship. In fact, it's evident here itself. Lordship has page 79.
Yes.
Now, Lordship, this is to certify occupational health and safety management system. It says occupational health safety management system.
Correct.
Of so and so. But Lordship, in bold, it says ISO 45001:2018. So this is the ISO certification. Now, Lordship may come to.
This may be common for lot many.
Yes, Your Lordship. Lordship now come. This is the expired one. One sec. This is the expired one. Lordship may now see page 80. It's exactly the same. ISO. Why? Because in 2021 is when ISO came in. Lordship, which is why I'm placing the bundle for the previous ones. Then Lordship will understand the difference. Even I was misled. Lordship, when we dug in more and we realized that was what Lordship will become very clear if you look at the bundle, because then the comparison is between 2021 prior and 2021 post. 2021 is when ISO 4500 came into being. Before that, it was OHSAS.
Correct.
Lordship has the bundle.
So OHSAS has a different code.
Yes, Your Lordship.
Code number.
Yes.
That was 18001207.
Yes, Your Lordship.
And this is ISO 450012018.
Yes, but Lordship may look at the bid document at page 44. They continue to say OHSAS. And Lordship may look at the minutes of the meeting in the rejection column. The reference is always to OHSAS, which is why even our letter when we wrote back saying that please see this current certificate, we said page 100, Your Lordship.
AIDC. You have sought for a wrong document. In fact, in your this thing itself, if in spite of the corrigendum, he could not prescribe the proper document.
It did not say ISO. It's continued to maintain.
Lordship, that is correct. The corrigendum also says OHSAS.
Why? So you have asked for a document which has already become obsolete.
Lordship, that senior counsel.
No.
Lordship, the OHSAS certificate, which was named in the tender document, Lordship, which was corrected by the corrigendum, when anyone has approached us saying that OHS has gone, it has become obsolete and changed to the name of OHSMS or the ISO 45000 number, we have allowed them, and those emails are on record, Lordship, and that we have allowed anyone who came up with the current certification.
They didn't bother to correct it in the.
Lordship.
Why this after corrigendum also it has become wrong? You don't have any specialist in your department?
Lordship.
Is aware of all these things? Updated with what is available in the market, what is not available in the market.
Lordship, look at page 5 of the documents I have tendered, which is a different tender by the government of Assam. Lordship, my submission is and my understanding is it is a nomenclature. They continue to refer to it as OHSAS.
It can't be, madam. It can't be.
Look at this document.
Can't be. How can they? I mean, these are two different documents.
No, Lordship, it's not. It's an ISO certification.
Earlier it was OHSAS. Code is different.
Yes, but
now it has become a different now earlier it was
OHSAS.
Occupational health and safety management system.
No, that is the common thing everywhere. Lordship, look at it. That is what you certify.
Looking into that.
Yes, that is common.
But only thing is that the code.
ISO, now it's ISO, before it was OHSAS.
But it is given by ISO only, isn't it?
Yes, your lordship, that is my submission.
Or it's a different organization?
First, it was given by Nimbus, now it's Pyramids. And lordship, the industry players know it. And lordship may look at page 5, which is another tender.
Yes, what is there?
Page 5, your lordship.
Hmm.
This is a government of Assam tender for construction of indoor stadium along the wall gate.
Yes, they have mentioned as what?
Lordship may now go to page 9. Lordship, I have paginated, page 9.
Page 9.
Yes, your lordship, and there's a table and the second last row. Quality. Lordship has it?
Page 9.
Yes, your lordship.
Page 9, yes. Second, yes, quality management system 90012015 and
OHSAS 1800.
So they have changed the code name.
No, it's again OHSAS.
OSSS, but the code is different. That is
301 2007. Which is the first one, in fact. And this is non-existent, your lordship.
That's what I'm saying. Earlier, it was 1800120007. Now it has become 45001282018.
Yes. A bit to date to PSLS. Device letter. 26, sir.
It is this.
Lordship, this bid of page 5 is a current bid of May 2026. Even in May 2026, they refer to OHSAS, the old thing. Lordship, ISO will now not certify. If I want to qualify under this occupational health and I go for certification, Pyramid is not going to give me a OHSAS. Nobody will get an OHSAS. This is a red herring, your lordship, with respect, and it's unfortunate. It's unfortunate that a bidder who did not a bidder. It's unfortunate that a party who did not bid came after 3 months, actually raises a point which the industry players knows it not to be true.
Okay, we'll look into it.
Yes, sir. That is.
We'll look into it. Yes, records.
Yes, Lordship.
Lordship, the minutes also referred to as OHS when the whole table has OHSAS. So understanding is OHSAS is the ISO certification. Nobody doubted it, your lordship. AIDC, nor the players. Obliged, your lordship. I'm very
to see the minutes first, or Lordship would like to
So
see.
you give me the records.
It's
You give me the record about the whole records, then let us see what's there.
Lordship, would you like us to file an affidavit to convert this?
Not required. I'll keep it on record.
Yes.
If required, I'll mention.
Thank you.
just first we have submitted the selected tenderers documents and the minutes, Lordship, and we have the copies of the participants also. First one is minutes.
First one is minutes.
That is the party. That is the party who was selected, Lordship, the bidder.
Now this contains what?
This contain the bidding document and the record submitted by the bidders, Lordship. The
Bidding
minute contain how it was evaluated. That is in the plastic folder, Lordship. That is the minutes.
Your people are having tea or coffee while doing these minutes.
Lordship, may I call in?
There are marks here.
Okay, but that He says it was accidentally spilled into the
It always does in accident only. Nobody willingly does it.
Lordship, absolutely.
Was there any private meeting?
No, Lordship,
There's no private meeting.
no private meeting. They were given a query period, they could raise the queries which were answered to Lordship.
This document was already there.
Already on record.
Already there. This has been brought on record.
Yes, Lord.
What are these documents?
But may I please?
What are these documents?
Sir, that was the auction result that was being published.
When was the auction? When was the auction? What was the auction date? I forgot.
13th of October.
13th of October, Lord.
13th of October.
Yes, Lord.
13/10/2025.
Yes, Lord.
Okay, 13/2025. Who is this Bohra group? Is it before this court?
No, Lordship.
So there was an email exchange between Bohra and one of your officers.
Right.
That Bohra group, they had already, I mean, way back in 3rd September 2025, almost a month before, pointed out to you
Right.
that this certificate is no longer available.
Right.
So they have requested for this 45001.
Right.
What have you done on that? You knew about this, that this has become select.
That proves they knew about it
They
and
knew
they
about
allowed them
this.
to participate.
Huh?
They allowed them to participate with the certificate, which is
Like, how can you allow them? Whether that is there in the bid document?
the query. It was raised within
No, whether that is there in the bid document or not.
the name was not there. Exact name was not.
You have written somewhere that shall also be considered with other qualification eligibility criteria as mentioned in SPC document. How can you write to them? One particular group.
Because the query was raised by them on through email also. That was what responded to.
But that should have been given to all them.
That could have been published in the website or whatever.
And it was done 1 month back.
On 3rd of
I
September.
mean, more than a month.
But closing date for the query was 15th.
In spite of knowing this, that document is no longer available and parties won't be able to give this document because the document is already become obsolete.
That is correct.
And in spite of, coming up with a clarification, we kept mum.
Yes, certificate of kind of disqualified. Exactly. It will correct my
How many of them you have cancelled for this OSHs?
Lordship. For not giving the we have cancelled by not submitting the certificate, Lordship, OHSS. Lordship will give me a moment, Lordship. I'll just.
Minutes are as it doesn't say whether it assumes that we are doing the right. That is the point.
So
minutes
these
has the
these
chart.
three files are of these three
Four
bidders, four bidders.
bidders. They are who participate in the auction process, as in for the after they are qualified technically. Lordship.
4 or 3.
Three were before the order of this honorable court, which allowed the edifice to come and join the auction process. Lordship. Otherwise, three were qualified.
Yeah, what about the others?
We have the records.
When we wanted to see the others, how you have rejected them? That is that.
Lordship, the minutes have.
The minutes, there is
Not-
nothing
yes,
much in
yes.
detail. What are the documents they have submitted or not?
Documents we have. What they
Rejected
have,
because of OHSS.
what they have submitted, the documents we have the copies. Lord. We'll just place it on the.
So these three you have rejected.
Yes.
Because of I mean non-providing of this thing, this
We
certificate.
have rejected for non-providing. I'll.
Chaudhary and Sons.
First is number on the minus is number 3. Then
One is Cantor Steel, one is
yes, Lordship, that is rejected for not giving the certification. Disqualified due to unavailable OHSAS, Lordship. The first file, Lordship has name. Cantor Steel, India.
these three are rejected because of non-submission of the document, right?
Cantor Steel is yes, Lordship. The other two files, the names. Industrial assets.
There is no pagination in these files.
No, Lordship.
Why have not you done the pagination? How is court is going to look into? You have given a front page with some paginations. But the file is not paginated. How this court is supposed to look into this? You don't have any officers to paginate these files? How am I going to look into this?
Lordship, nothing.
We have given sufficient time to you.
Lordship has.
Then why it hasn't been done? Are you supposed to give those documents like this? Am I going to supposed to see all these pages reading one and one?
Of course not, Lordship. That.
How am I supposed to read this?
Lordship, Lordship will allow us sometime. We'll get it all the pagination and all the certificates.
There is no pagination, nothing. You should make an index.
Lordship.
At least the particular documents. You know why this court has asked for these documents? Wanted to see whether these OSS documents was given or not, whether you have correctly evaluated or not. That's what the court wanted to see. That at least the relevant documents you should have given the paginations. ARDC doesn't have people to do it.
Of course they would. Will just give us some time. We'll get it done. At this point of time.
This is not the way to give files to the court.
Absolutely not.
Am I supposed to sit with this matter for 1 month? Go one by one. Too much of irresponsibility. There's no pagination at all. The front page, there are some paginations. Now, how do I going to refer to this?
Lordship,
You get each and every pages.
No, Lordship, of course, no. We'll get back with the correct pagination, Lordship. Today only, Lordship. Lordship will like.
Singular, that much of little bit of sense should have been there. Little bit of sense. These huge volumes I need to look into,
Lordship.
and there is no pagination.
Lordship, that of course is our fault, Lordship. We do apologize for that.
Okay, we close this and they let them I mean do the pagination and give it back to me.
Yes, Lordship, we'll submit it to you.
Just give it to me today itself.
Yes, Lordship, we'll give it.
Return them. What else is there?
So far as today, submissions has been.
No submission has been made. Only this little bit of clarification. Nothing is required.
So far as
Nothing is required, Mr. Das.
May I please, Lordship, just, Lordship will submit the minutes, all the 20 files.
I don't want 20 files. I said the ones that you have rejected.
Only 8 files.
What grounds you have rejected?
That's
You have
fine.
rejected. You say that like the OSS certificate was
But-
not there.
Well, 8
So
files.
I need particularly those files.
Yes, Lordship.
How you have rejected them?
Yes, Lordship.
Whether you have rejected in the similar ground or not.
Yes, Lordship.
I hope you understand
Yes,
that.
Lordship. Absolutely.
I'm not looking for all those things.
On-
At least those pages would have been, paginated. Minutes and all. You take the minutes also.
Yes, sir.
Give me all together. Now, when you're going to give it to me?
Today only, Lordship. I'll give it before the court hours.
Okay.
Apply your lordship in that sense.
Okay, we are concluding this
Yes.
and like they'll just give me the files. I'll just record it that like they have given me the files. These are all Xerox copies, right?
Yes, Lordship. Because this is all online, we have taken printouts, Lordship.
Correct. That's
So we can hand over the files to the.
right. Ms. G. Goswami, the learned senior counsel, assisted by Mr. R.C. Das.
RJ Das.
R.C. Das, the learned counsel for the petitioner. You take the item numbers for the petitioners. Also Mr. B. Deka and
Eka Koti.
A. Kakoti, the councils, learned counsel appearing for AIDC. You are also?
MSTC. MSTC.
Okay, Mr. So-and-so for MSTC. Hearing concluded. Judgment reserved. I'll record that leave,
we'll give it.
whatever files you have
Yes, sir.
given, I'll just put it here.
Yes, sir.
Okay, on the order sheet only.
Yes, sir.
And other matter, heard Mr. S. Das, the learned counsel appearing for the petitioner, and others the same. And anybody else is there? Mr. So-and-so. Item number 9. 9.
Right, Lordship. And I apologize for the inconvenience, Lordship.
This is not the way to do it.
Yes,
I
sir.
mean, you are aware of this. I mean, how the court is going to look into this. This is a simple thing. Yeah, class 5 student also knows about this. And your AREC people doesn't know about this.
Lordship, it was our fault. We apologize, Lordship.
Yes.
May please endorse. Not by this criminal petition. I'm challenging the
Speak
impugn
little
FIR.
louder, Mr. Secretary.
My lord. By this criminal petition, my lord, I am challenging the impugn FIR. Also, you'll find the FIR at page 94. Page 94 is the FIR, my lord. It is related to, my lord, some forced document.
Yes.
But the petitioner for lordship passes the plot of land.
You are who? You are Mr.
Jogeshwar Nath,
Jogeshwar Nath.
my lord.
You sold it to Muksed Ali.
My lord.
Hmm.
But I purchased it
Hmm.
year 1987,
Hmm?
97. In the year 1997, I purchased the plot of land, my lord.
Yes, 1997, that,
From the mother of the informant.
hmm,
Those will find the sale deed at page 19.
place 19.
Page 19, my lord. And this is the translated copy, my lord. Page 20 is the vernacular.
Page 19.
Page 20 is the vernacular one, my lord. After purchasing the land, my lord, land was mutated in the name of the petitioner. And my lord, thereafter, my lord, he also paid the revenue receipt, revenue and all, my lord.
This was done in 1980,
97.
1997, yes.
Right.
1997.
Right.
Then you resold it when?
In 2021, my lord.
2021,
My lord. Page 28,
page 28.
my lord.
You have not given in type copy of this.
My lord.
It can't be read. I don't know how these documents are passed by the registry. It can't be read.
Well, in my copy, it is clear, but in
Read. You see this copy, how can it be read?
Sarah's copy is not clear, my lord, perhaps. Sarah's copy is clear. My lord. After selling the land to Mukshed Ali, the informant, my lord, he approached the learned civil judge one by filing a title suit. So we'll find the title suit at page 41.
Yes, after this, what happened?
My lord, the informant, my lord, he approached the learned civil court
Hmm.
by challenging the sale deed as well as the mutation order, my lord. So we'll find the title suit at page 41. Page 41. It was filed on, my lord, 2022.
Title suit number
5.
5 of 2022.
My lord.
And this FIR was filed when?
FIR was lodged on, my lord, 28 November 2023.
20 November 2023.
My lord.
Title suit was filed earlier.
Must earlier.
And then what happened in the title suit?
In the title suit, my lord, as there was no injunction granted in favor of the, my lord, plaintiff, the informant herein, my lord, he approached the, my lord, criminal court, criminal authority by filing the imputed FIR. Only to give a criminal color to the civil dispute, my lord. If
This case is still pending, the title suit is still
yes,
pending.
my lord, still pending. Also, will find the prayer at page 56 in the title suit. What is this prayer, my lord?
56.
Yes, my lord. A decree declaring right, title, interest, and possession of the plaintiff over the Schedule C land. Decree declaring the registered sale deed number so and so, dated so and so, and number so and so, dated so and so, alleged to have registered in the office of the senior sub-register, Gauhati, are void, illegal, inoperative, and not binding upon the plaintiff. A decree of recovery of possession
of the Schedule C land by removing men and materials from the defendants from the Schedule C land and put the plaintiff in first possession of the Schedule C land. Decree for permanent injunction restraining the defendants, their men, agents, employees.
Okay, got it. Mr. Saikia. Now there is a sale deed, right? Whether it's a correct sale deed or wrong sale deed. No, hear me out first. I'm asking you something.
Yes,
Please don't interrupt when the court asks you something.
yes, Lordship.
Correct. The court asks something, please respect the court and please hear out.
Yes,
If court is not asking you something relevant, then you can say.
Oblige you.
Asking you
Oblige,
something.
oblige.
So when I'm asking you something, you please reply. I'm asking you your sale deed is there. Whether it's correct or incorrect, it is there. And you have challenged that sale deed by filing this title suit. Correct? Now a sale deed can be cancelled by whom? Only by a civil court, not by anybody. So you have approached the civil court. Correct? Now the case is pending, injunction is not given in your favor. Why you have filed the FIR?
That's why, my lord, kindly see.
That's what I'm asking.
The Lordship, I will answer you.
No, I'm just asking. I'm here. I'll have to hear him out. I'm just asking whether the sale deed can be cancelled by a criminal court.
My lord, when he found that he came to know later on that a forced sale deed had been made by them and
Whether it's
that inquiry was
yeah,
conducted.
that's what I'm asking. It's a legal point I'm asking.
My lord, that is why.
I'm asking a legal point. Whether it's a
my lord,
document, whatever, whether sale deed can be cancelled by a criminal court.
My lord, my prayer will be civil court. I will come to that. My prayer is that when I file an FIR, immediately the deputy commissioner and the district magistrate made an inquiry and found that sale deed which he has managed, that sale deed is not there in the DC office, in the register office.
Okay.
Not there. Kindly see, my lord, page 133, inquiry.
Understood.
Inquiry, and on inquiry came to know that it was the fourth document they made. No such sale deed is there in the office of the sub-register in the DC. Then, my lord, the district magistrate, my lord, after making proper inquiry at page 136, I have filed the affidavit. Page 136, my lord, kindly see. Seen and perused the letter number so and so received from the Deputy Commissioner of Police, Crime Branch, regarding fact, forced land documents prepared by forgery and manipulation of original records and also by impersonation, which were used subsequently for mutilation of land by unscrupulous elements in their name, depriving the genuine owners and requesting for review of such.
Have you submitted this document before the civil court?
Malad civil court, this should have been filed by the respondent for the cancellation of sale deed. But when he came to know that actually these are false documents,
Correct.
so he filed the FIR. And what's the inquiry was conducted, and on inquiry it was found
that this inquiry report was submitted before the civil court or not. That is the simple question the court is asking.
that will do, but
That will do means whether you have done it or not.
no, my lordship is correct from one side. The other side is that.
Other side I'll hear. I'm just asking.
Other side, my lord, I will make the submission.
See,
because first thing your lordship has.
It would have been. You are not hearing me.
No, lordship.
It would have been very easier for you if you would have submitted the inquiry report before the civil court, and civil court, after going through the inquiry report, probably give you the give you the relief. Would have given you the relief.
Civil suit was filed later on. This inquiry was conducted by the deputy commissioner.
I'm saying that after when the civil suit is pending, whether you have made any effort to submit this inquiry report before the civil court or not. I'm just asking you. I just wanted to know, nothing else.
No, I could not, because they immediately filed selling the FIR.
Correct, but civil case is still pending.
That is pending for cancellation of the.
Whether that is there, is there any interim order on that? Is stay or something like that?
No, my lord.
Nothing is going on. Nothing is there. The matter is still on.
That is whether this division will lie. I have brought the. I have seen the. I have brought the judgment also, because the judgment that they have produced, that judgment is in favor of this respondent.
I do not know what judgment you're talking about, Mr.
Malad, when they see the, I will amend it.
No,
Malad.
I've just started hearing he has not placed any judgment as yet.
All that matter, no.
Or I don't know whether he have placed any judgment before this.
They have in the case itself, they have referred the judgment, lordship, in their case. Malad, I will make my submission, lordship. Lordship may kindly
hearing, Lordship.
Lordship may kindly turn to page 47, paragraph 11 of the title suit. When he came to know about the possession of the land by the petitioner, that after obtaining mutation over the suit land, the plaintiff on 7/1/2021 visited the office of the Mojadar Beltola Mauja with the intention of clearing the land revenue of the Schedule C land. On such visit, the plaintiff was completely shocked to discover that the land revenue for the suit land was already paid in the name of defendant number 1, the petitioner here in Malad. The plaintiff thereafter requested the Mojadar to provide the plaintiff a revenue clearance certificate, and accordingly the Mojadar on 27/1/2021 issued the land revenue paying certificate of the Schedule A land of the plaintiff. So, my lord, he came to know, as per his statement before the civil court, on 7/1/2021, 7/1/2021, he came to know, and he lost the FIR on 28 November 2023. After more than 2 years.
Yes.
In the present case, my lord, the petitioner approached this honorable court praying for a bail, my lord, wherein the lordship will find the bail order at page 111, and in 113, what was the observation made by this honorable court, my lord? 113, my lord. It is also submitted by the learned counsel for the petitioner that in this respect, a civil suit is pending, which has been lost by the informant Upen Kumar Das against the present petitioner and Muqsid Ali, which is pending before the Court of Learned Civil Judge number 3, Kamrup M. It is also submitted that the said suit, the prayer for cancellation of the registered sale deed number so and so, dated so and so, and the registered sale deed number so and so, dated so and so, has also been made. On the other hand, the learned additional public prosecutor has produced the case diary of the crime branch PS case number so and so, and has submitted that there are incrementing materials against the present petitioner in the case diary, and the offense alleged has been committed in connivance with the officials of the land record department. I have considered submission made by the learned counsel for the petitioner as well as gone through the materials available on record, including the case diary of crime branch PS case number so and so. It appears from the record that there was a registered sale deed in favor of the present petitioner executed by the mother of the first informant, and a civil suit is also pending between the first informant and the present petitioner in the Court of Learned Civil Judge number 3, Kamrup, where the genuineness of the sale deed in question is at issue.
Okay, that the bail was granted to you. Now, let us see the inquiry report. Where is the inquiry report?
That
Mr. Saikia was referring to.
That inquiry report is a report submitted by the, my lord, DCP crime. This is not an inquiry report, in fact, my lord.
Where is that?
Page 133, my lord. 133. By this intimation,
Once. Yes, 133.
133.
Okay, yeah. Let us see what was there. It was addressed to Deputy Commissioner
My lord,
by
by the DCP crime, my lord.
DCP crime. Okay.
My lord.
Information revealing fake and false documents prepared for forgery and manipulation or been record change which were used frequently communication and academic pricing strange crime laws strange registration case number. This case number is what?
This is the police case number, my lord,
Police case numbers, I mean,
which is under challenge here in the,
that FIR.
my lord.
Okay. It reference to subject. Oh. The report is dated when?
Report is dated, my lord,
23rd February or what? No, no.
23rd February 2024. It was never intimated to the petitioner, my lord. And my lord, DCP crime has no authority to intimate the deputy commissioner to, my lord, correct the land record when a title suit is pending over a particular plot of land.
But how do you answer this, Mr. Saikia?
My lord.
Their sub-registrar's office doesn't contain any record.
It is there in the volume, my lord.
Hmm?
The certified copy I have given, I have annexed, my lord. That is a certified copy. Had there been no record, they could not have issued the certificate.
Where is the original one?
Original copy is the with the sub-registry.
No, there are two copies given, right?
My lord.
Two originals they usually make. One is given to
No, initially, my lord.
one they keep it, and other one is given.
Nowadays, this is a, my lord. Earlier, my lord, the original copy was kept in the record of the sub-register.
But you will be giving.
Certificate copies was provided to the persons, my lord, parties. Earlier. Nowadays, my lord, the original copy also, my lord, is provided to the seller or purchaser, my lord. Certificate copy did.
Yes, the inquiry report goes against you.
Yes, yes, my lord.
So now on the face of it, how the FIR can be, FIR can be, FIR can be,
Yes.
how your case can be allowed and FIR can be set aside and was.
Well, on the basis of this report, on the basis of this
There's
intimation,
report, see, there was an FIR file
my lord.
on because of the FIR, an inquiry was conducted. An inquiry found that like, this document is paused one,
My lord.
and he's right that like he sees that the inquiry has come out.
My
Then he has sufficient materials with him to share that that document was fake. So that way he filed fee. That is the reason he has
that particular document which is reported by the DCP crime is under challenge before the trial court, my lord. Before the
that's a
civil
different
judge.
thing. That's a civil suit. That is
The civil
that
suit.
is pending.
Even, my lord, if I cannot prove the authenticity of the document, my lord, in the civil court, the civil court will also, my lord,
The civil
direct the
court will
competent
cancel the
authority.
registered. The civil court will cancel the registered whatever the alleged registered cell did.
My lord.
But what will happen to the crime that you have committed?
Yes. My lord, if I committed any crime,
So that trial will decide.
he could have, my lord, lost the FIR immediately after knowing about the incident.
Correct. He may not have.
He has lost the FIR after more than 2 years because he knows that the land was sold by his mother. Land was sold by his mother. Now his mother is not there. She has passed away. Now he is claiming the land.
No, but what about the inquiry, Mr. Saikya?
Inquiry, my lord, this inquiry has
Have you placed this inquiry?
My lord, it was challenged before before this honorable court, my lord,
Hmm.
along with the order passed by the deputy commissioner, district commissioner. But my lord, as the order passed by the deputy commissioner was a appealable order, the writ petition was withdrawn, and my lord, we are approaching the revenue board again.
Then you'll have to do that. You'll have to do that because see, on the face of this inquiry, see, FIR can be set aside and quashed only in rare circumstances. That you know, settle law.
My God.
In exceptional circumstances, correct?
Right.
Now, on the face of this inquiry report, which the inquiry which has been done on the basis of the FIR,
Right.
correct? Which court is going to do? Which court is going to set aside the FIR?
My lord,
Just tell me that.
This report, while submitting this report, the petitioner was never asked to submit his documents, my lord.
That is not
never
required.
asked.
This is an.
They have made an expert inquiry.
Mr. Saikya, this is not. This is an inquiry or investigation on the basis of an FIR. Correct.
My lord.
So this is not a departmental proceeding or a proceeding where the natural justice and all these things will come.
My lord.
This is an investigation they have done in the offices where this registration has been done. The office opined that this seems to be a fake because e-book also doesn't contain any number, this particular number. The document is not available. In addition to that, they have specifically named the concerned persons who were there at that point of time in the circle, who were working at that point of time, naming them with during those period. So authenticity of this, this thing has to be challenged by you. If you say that, if you say that no, this inquiry report is not correct, it has been done with some ulterior motive or whatever.
Yes,
so that you'll have to do. On the face of this inquiry, which has been conducted on the basis of the FIR he has filed. This has come to the notice of the court now. And on the face of this, how this court is going to take any kind of adjudication of this? Or the court can say this is not correct. On what basis court will say?
My lord.
No, you tell me, Mr. Saikya, on what basis this court will say that this inquiry is not correct? You tell me that.
Because the investigating authority, my lord, they are always hostile to the petitioner, which will be reflected from page 136.
What is there on 36?
136, that is the order passed by the district commissioner. He has directed the circle officer to cancel the mutation order without issuing any notice to the petitioner. On the basis of this,
Have you challenged this?
yes, my lord.
Where?
And my lord, that is why my lord, writ petition was filed. Writ petition was withdrawn yesterday, my lord, because this order is appealable order.
Then you argue this case later on. I mean, don't argue this case today. You see there, I mean, see, first of all, whether DC has the power to cancel the mutation or not.
Right.
Saying that, now whether it's a fake or forced,
My lord.
a sale deed is with you.
Sale deed is with me.
Correct. Man, that's what you are saying, and your sale deed is with you. The one document is with you. Now that only some specified authorities can only cancel that sale deed. Once sale deed is given, the sale deed is registered. The register becomes functus officio. He doesn't have any power to do anything. That is the settled law. It seems.
No.
I may not be correct. If I'm not correct, then please correct me. So he doesn't have any power. Only the civil court has the power
Yes,
to cancel it.
Right.
Correct. Now, if DC has cancelled your mutation on the basis of that cancellation on the
This
sale
report.
deed, then if you challenge that,
My
and if you are challenging that, then you argue this case later on. What is the point arguing this case now?
my lord. Then my lord,
No, you see, because this I'm telling you one thing very honestly, and free and frankly, that on the basis of this, what Mr. Saikia has pointed out, on the basis of this inquiry report, on the basis of, which is on the basis of the FIR,
my lord.
on the face of this inquiry report, how this FIR can be caused?
My lord, the duty of the investigating officer is to investigate an incident on the basis of a FIR.
He has done so.
If he finds anything, my lord, if he finds anything, my lord, it is his duty to submit the search sheet. He has not submitted the search sheet till today. And intimated the deputy commissioner to cancel my petition.
When it was when was the inquiry report? 2024,
24, my lord.
24.
23rd February 2024. Till date, he has not submitted the search sheet, my lord.
That is one aspect.
His duty is to submit the search sheet. My lord, the investigating officer in the criminal proceeding, my lord, on the basis of the FIR, he has to investigate the matter, my lord. After getting anything against me, he at liberty, my lord, he had to submit the search sheet. Instead of submitting the search sheet, my lord, he is reporting the deputy commissioner that this incident took place. These are false documents to cancel the mutation. Sitting over the authority of the civil judge. Get it. Recently on 18/5 also, my lord,
Where is the FIR page?
FIR loss you will find at page 94.
So this complaint was filed before the Commissioner of Police Gauhati,
My
and the case was registered by the Crime Branch Police Station,
lord.
Gauhati.
My lord.
So that is why the Crime Branch Police Authority has conducted the inquiry, right?
My lord.
And thereafter submitted this report to DC also. I
Yes,
don't know if they have some protocol in that.
My lord, his duty was to submit the search sheet, or alternatively, my lord, along after filing the search sheet, he could have intimated the deputy commissioner not to give permission for further sale.
No, that is why I'm saying that like this should have been if you are aggrieved by this report, then you should have challenged this.
Possibly.
You challenge this, and on the face of this report, it will be difficult for any court to go into
My lord, I have
quashing of the FIR.
grant some time, my lord. In that case, my lord, I will oppose the
You
remedy board
approach,
first.
if you have challenged this, you see what happens there.
Yesterday,
be better
this
for you.
petition was disposed of yesterday on withdrawal, my lord, because this order is appealable
This is
order,
appealable order.
my lord. So I will file approach the remedy board within this week, my lord.
Now we can give you some time. Mr. Saikia, let him take him some time. Let him give some.
That's the minute, my lord. Lordship. Finally, CD has suppressed some material facts. My affidavit may be seen.
Yes.
Affidavit in opposition.
Page.
My lord. Affidavit in opposition.
Affidavit in opposition. Page.
My lord, page. I'll see the
You are
conduct.
Bhupen Kumar Das, eh?
Dr. Bhupen Das. Page 165 for a while will be seen.
Page 165.
65 of the.
Yeah.
Lordship, see that this petitioner has sold the land again to one Muhammad Mokshed Ali.
Correct.
That page 165. And Mokshed Ali purchased the land. And again, the wife of Mokshed Ali, my lord, purchased the land at the next page, Lordship, page number 141.
141.
141. The conspiracy, my lord, the forced conduct of the petitioner along with his group.
What is this? This
This is-
Labani
yes,
Das. Labani
yes.
Das is the mother of Bhupen Das.
Bhupen Das. And the same land
When she expired?
expired in 2016.
Huh?
Page 179.
2016.
Yes.
And how can this be signed?
That is why, my lord, these are all documents. All the group has entered into. That is why some of the officials have been arrested. That's the minute, my lord. The officials have been arrested, including the advocate concerned, were here behind the bar for many months. Lordship, page 179. The Rabinna Baladas died, the mother of this respondent, died on 26/6/2016.
Marjina Begum is who?
Wife of my lord Mokshed Ali. And Mokshed Ali purchased the land from Jogesanath again. After if he purchased the land, what prompted his wife to purchase the same land, my lord, from the dead man?
This is 2020. The other one is 2021.
21. And the mother died on 2016. How can I sell the land? How my mother can sell the land to his partner, Mokshed Ali? Mokshed Ali has purchased the land from him. If he has purchased, his wife again purchased the same land from my dead mother. Great conspiracy has been hiked up. That is my humble submission, my lord. This is not a fit case at all. I have brought the government of the appeal also. When there is the great serious and criminality on the part of a person, my lord, affair may not be, my lord, interfered, lordship. These things have been suppressed in this petition.
How can
And I have come to know that they have challenged the order of the empirical report of the DC, and the court did not want to interfere. That is why he has withdrawn the case of dismissal withdrawn. Lordship, please, the copy here my friend has not brought, learned friend. The writ petition has been dismissed and withdrawn because the court found that the inquiry that they have challenged by a writ, court did not like to entertain. My lord, actually what happens? My mother died in 2016. And after the death of my mother, my lord, he has not, this Mokshed Ali did not come before the court. Mokshed Ali's wife again purchased the land, my mother, the same land. And there is no sale deed, my lord, my government advocate is here. Records people they have brought. There is no sale deed in the office of the sub-registrar and the DC. The entire book was examined and found that these are all forged documents. So there is a criminal liability, my lord. Lordship, I will press one judgment before Lordship.
What about this document, Mr. Saikia?
My lord, how can I know about this sale deed, my lord? This is not by me. It was by one
this is
Marjina Begum.
by your wife's name is there.
My wife's not.
No,
It is not my wife,
the
my lord.
person here you have sold.
Yes,
The person you have sold.
my lord. I was not aware of this sale deed, my lord.
You should take instructions on this. Because you have sold the land to this person. So it is
He has sold the land to Mokshed Ali.
Supposedly.
And Moxel's wife against purchased the land from a dead man. So here is the criminal, my lord, get conspiracy. And about that, I have brought a judgment. Well, the civil suit, the only ground that civil is pending. The honorable, my lord, court held that the civil suit may be there, but
Was the order passed?
My lord, that is what I am reading, my lord. Learned counsel for a petitioner fairly submits that he may be allowed to withdraw the petition in view of the statutory remedy appeal available under Regulation 147 of Assam Land Revenue Regulation 1886 before the board of from orders original or appellate passed by the Deputy Commissioner, Settlement Officer, or Survey Officer. Prayer allowed. Mr. A. Vatsadi, Learned Counsel, Revenue Department for respondent number 1, so and so, so and so. Accordingly, the petition stands closed on withdrawal, which a liberty to the petitioner to avail the aforesaid statutory remedy.
let them try there, my lord. But this,
So we are giving you some time.
My lord.
Then you come back. How much time will it take?
3 weeks time. 3 weeks. In the meantime, I will have to enforce the revenue for my
my
lord.
lord, that,
Because
my lord,
there is a delay.
under my humble
Because the
submission,
appellate order is, my lord,
my lord,
appeal should be preferred within a period of
my
90
lord,
days.
that
That
is
order
the,
was passed in 2024. So I will have, that delay will have to be confirmed, my lord.
that will be, my lord, separate stage. They will challenge it and they will argue the case before the Board of Revenue. But here is the criminal case, how he can avoid criminal case. My lord, can you see this judgment, similar case came up before the Honorable Court in the Supreme Court.
And well, while I sold the land to Mokshed Ali, it was the Deputy Commissioner himself, Mala, who gave me the permission.
No such deed is there at all. Can you see, my lord? This is the case where a similar case, my lord, this Gangadhar Kolita approached the Honorable Court for quashing the affair. My lord, kindly see, dismissing the appeal, the Supreme Court held. My middle portion, my lord. If the allegation in affair are not frivolous, malafide or facetious, it cannot be simply quashed.
No, Mr. Saikya, you do one thing.
Hello.
See, we are fixing it after 2 weeks.
My lord.
After 2 weeks, see, first thing is that like whatever instruction you have to take it on this sealed it.
On margina, my lord.
Or you take the instruction, whatever is there.
My lord.
Then we'll hear it out because it seems like there is ground what you say.
My lord.
We are just giving you 2 weeks.
My lord, my humble submission.
2 weeks.
Not may be treated as a pardon.
We are giving them. We are giving them 2 weeks.
My lord.
Let him bring his instructions on the sale deed that you have shown.
Yes, man.
Okay. Then if there is nothing is there, then we'll see what is to be done. We'll see what is to be done.
My lord. Matter may be treated as pardon.
No, not partner, no partner, sir. So partner means like if I cannot take it up, then it will be released after 1 month. It will be difficult. And after 16, I will not be there. So it will be difficult. So whichever court, court will hear this out. But let him get some instructions, whatever is there. Because otherwise, on the face of this inquiry, it will be your FIR cannot be. I'm telling you, your FIR cannot be crossed. On the face of this inquiry. Only thing is that you have said that like you are challenging that inquiry report. And if you are challenging it, if there is some order you get, it's better for you. If you don't get it, then it will be difficult.
Oblige, my lord. Oblige.
Heard Mr. I.S. Sakhya, the learned counsel appearing for the petitioner. Also heard Mr. R.C. Sakhya, the learned senior counsel, assisted by
JP Borua.
JP Borua, the learned counsel appearing for the respondent number. Appearing for respondent number 2. Respondent number 2, Mr. B. Sharma for respondent, learned APP for respondent number 1. On the prayer of Mr. I.S. Saikya, the learned counsel appearing for that, let the matter be listed after 2 weeks.
Right.
Yes, Saikya, you can keep this. Okay.
My lord.
It may be required.
My lord.
Oblige, my lord.
Wait, please, Your Lord. What is an appeal, Your Lord? Only one of the accused in item number 39 has already been enlarged on bail. And today, my lord, it is listed for consideration of, my lord, IA for item number 38, my lord.
Then I.
NDPS matter, my lord.
Yes.
May I quickly give the factual position of this matter, my lord?
But what is the ground
My lord,
you're behind the bars for how many days?
2 years, 6 months, my lord. Punishment is 7 years and 50,000 fine. Contraband is ganja, my lord. 2 kg 200 grams intermediary, my lord, quantity.
2 kg?
2 kg 200 grams, my lord.
Intermediate quantity.
Commercial is 20 kg and small is 1,000 gram, my lord. Now, my lord, there were 4 persons accused in this present case. Out of that, my lord, 2 were absconding, and that is why the case splitted out and proceeded against 2 numbers of accused person. One is item number 39 and another is me, my lord, item number 38. The conviction, my lord, it was granted under section 20B and 29 of NDPS Act, my lord. The prosecution, my lord, to prove its case, examined 6 number of witnesses.
Yes.
May I take your lordship's attention directly to the witnesses, my lord? My lordship, may I kindly come to page 40, which is PW1, my lord. He is the one, my lord, from whom, my lord, he is owner of a, my lord, shop, my lord. He is owner of a shop. From him, my lord, one Dagapalla was seized, my lord. It was used for measuring the contraband, my lord. The weighing apparatus was seized, my lord, but the weight, that Doga was never seized and produced before the honorable court. May I read, my lord, page 40? My name is so-and-so, my father's name is so-and-so. I have not recognized the accused person who is present in the court today, and the accused person who has joined the court through VC. I have a small grocery shop at Baliding Bazar. 6-7 years ago from today, the in charge of Silonibari police station had taken weighing scale from my said shop and then took my one signature. After that, had given my weighing scale to my Jimma. I do not know what the police had done with my weighing scale. Now, page 41 cross, my lord. Last line, my lord. I have no knowledge regarding this case. Now, page 44, my lord.
So what is the difficulty in this?
My lord.
What is the difficulty in this deposition?
My lord, because PW1 from him weighing scale was allegedly seized, my lord, from which, my lord, the contraband was measured. Now, my lord, PW5, who is the IO of this case, my lord, he has done the investigation. He has filed the FIR also. And he said that he has done the measuring, my lord. The quantity is measured to be 2 kg 200 grams. But, my lord, the weighing apparatus was seized. But the doga from which is used.
But whether doga is required here?
Yes, my lord, because
the weighing scale.
Weighing scale, my lord, it is not the machine. It is the manual.
Weighing scale is supposed to be something where the scale is there.
My lord,
there will be one cursor That, and then when you put the, I mean, weight down there,
My lordship.
then the cursor will come.
But-
Then you will see in the scale only the what is the measurement.
Doga palla would be, my lord, the two
Kapalla is a different thing.
My lord.
This, I mean, it says about weighing scale.
wings.
If it is weighing scale is a different thing. But I don't know whether Doga Palla was used or weighing scale is used. If it is weighing scale, then weighing scale is a different kind of instrument, which is like, I mean, the goods are put down below.
There are, my lord, yes,
Then there will be a scale.
scale,
In
my
the
lord.
scale itself, you will get the
Says-
measurement.
Yes, my lord.
So Daga is not required there.
Yes, my lord. But here, my lord, they have said Doga palla.
Okay.
That is what my
Okay. Now, if somewhere else is
CW5 says, my lord.
if somewhere else it is coming as Daga Palla, then it's fine.
My lord.
But as far as this weighing scale is concerned, weighing scale is little bit different than this,
Yes, my lord.
but traditional Daga Palla.
Yes, my lord. That is, I'll come, my lord,
Okay.
because there are
Okay.
witnesses
Hmm.
who have put light into this aspect, my lord. Otherwise, my lord, the evidence of ocular evidence of PW2 is not of much importance in this particular case.
Hmm.
Except, my lord, PW5 has said he has done the measuring, my lord.
Hmm.
And PW1 says no, he has not done the measuring. There is contradiction, my lord. I'll come to that.
One says
He has not done the measuring, my lord. What has been done with the Logapalla, he doesn't know. And he do not know anything about the case. But, my lord, later on the PW5 says, my lord, it is the PW1 who has done the, my lord, measuring. That will come, my lord.
let's see PW5.
My lordship. Page 61, my lord.
Hmm?
Page 61,
Hmm.
para 7, my lord. Point number 7, my lord. Seven, my lord. I did not weigh the marijuana. I was watching while weighing. The marijuana was weighed by the owner of Dogapolla, Mufizuddin. He is the PW1, my lord.
Hmm.
And according to PW1, my lord, I do not know what the police had done with my weighing scale, my lord.
Hmm.
I have no knowledge regarding this case. Doga আৰু পাল doga কেইটা কথা কৈছে কৃষ্ণ
Who has been granted bail? You said somebody has been.
Yes, my lord, that is.
Who?
Co-accused,
Co-accused.
my lord, because the allegation is that, my lord, I am the,
I mean, how it was, I mean, recovered? I mean, you people are moving together.
I was the driver of a tempo vehicle, my lord. Some passengers boarded my vehicle. One,
You were
one
the-
child was there, my lord.
Huh?
One child was there among them. This ganja was recovered from his bag,
Whose bag?
from child's bag, my lord.
Huh.
And he was carrying it for his mother. Mother is the accused of item number 39. And my lord, some ganja was recovered from her person also.
That lady.
At her lady's person,
And the lady has been granted bail.
she has been granted bail, my lord.
On what ground? Let's see.
Till dependency of this matter, my lord.
Mr. Goswami, the main accused has been granted bail. He's the guy, supposedly the driver.
Well, it's my case, this is my case. From my position, I am not in the system. There are two kg, 100 gram required from them, not from me. Thereafter, they searched my house.
Then they found something there.
Or something below.
But you were traveling in the same thing, but he's the driver.
No.
There,
From her person, my lord. From her child, my lord. He was carrying the ganja in his bag.
No, it is not my case. The ganja has been recovered their possession. After their investigation, their police searched my house thereafter. The next day. From my house, it is alleged that 800 gram or something has been recovered from our house, not my possession. So,
Where is the FIR? Let's see.
The মোৰ কেছটোৰ লগত আপোনাৰ ৰিলেশ্যন নাই so মোক সাবমিশনটো দি ল'ব
Yeah, FIR. Where is the FIR?
FIR my lord, I have annexed the judgment, my lord. I appeal to the action. PCR has been called for, my lord.
PCR received, actually, we have.
Not page 46 of my IA, my lord. It is the cross-examination of PW2. Last para, my lord.
Who is to our PW2?
PW2, my lord. Actually, one committee was constituted, my lord. He was member, PW3 was a member, and they have, my lord, stopped the vehicle, my lord. That is how this case was registered. Now, he's an independent witness, otherwise, my lord. Cross part last para, my lord, page 46. Page 47, my lord, point 4. Where it, my lord? On that day, Janmoni's son was also there in the tempo, and he was minor then. Moreover, other 4-5 passengers were also there. When Janmoni's son was recovered from the tempo, about which he had information, then we were confirmed that ganja is there in this shop, in this tempo. I do not know among the 4-5 passengers which passenger was carrying the ganja in the tempo. But when chocolate was offered to the minor child of Janmoni, he pointed another person in the tempo. That is not me, my lord. And page 46, he has said, my lord, the accused person which I have seen through VC today was the driver of the tempo, and he had taken the persons carrying the ganja in the tempo on rent, my lord. Then, my lord, page 52 is a PW3, my lord. Page 53, para 4, my lord. Page 53, para 4. Married, my lord. We stopped the tempo, informed SP Lakhimpur over phone, and SP Lakhimpur sent police personnel to the place of occurrence, and police checked the bag of all the passengers of the tempo and found ganja in the bag which was carried by the son of the accused, Janmoni. Witness pointed his finger towards the accused, Janmoni. She has been granted bail, my lord. Then 54, my lord. 54 last para, this is cross part, my lord. Ganja was not recovered from the person of accused Niyamatullah. It was recovered from the possession of the son of accused Janmoni. And from Janmoni's place, my lord, police conducted search, my lord, and recovered some contrabands, my lord. And most importantly, my lord, only one inventory has been prepared. It was prepared, my lord, one inventory with regard to the seized part, my lord. Those are subject matter of, my lord, the final argument, my lord. At this stage, my lord, my only prayer that, my lord, because
Mr. Goswami?
Lordship, TCR we have to go through because the other persons were granted bail, but these persons putting cease were not different maybe. So we have to go to the TCR again, Lordship, for granting bail to that this petitioner, Lordship.
He's already argued the matter.
I'm only the driver, my lord. I was taking them on rent, my lord. And nothing is there on record which shows my conscious position with any of the material contraband recovered, my lord. How am I supposed to know, my lord, a minor person was carrying something, my lord, contraband articles with him, my lord. There are evidence, my lord, on record, which pointing out, my lord, some, my lord, complicity of Janmoni, my lord, and she has already been granted bail. Already 2 years, 6 months, I am behind the bars, my lord.
Let him go. What Mr. M does, the learned counsel, appealing for appealing for the applicant, appealing for the applicant, stroke applicant. So what Mr. BP Goswami, the learned APT for the state. The instant application of the section 430 bracket 2 of the BNSS 2023 has been filed for suspension of execution of sentence and stay of realization of fine that has been imposed on the appellate by judgment and order dated 5/12/2024 passed by the learned special judge, Lakhimpur district, not Lakhimpur, in special NDPS, special bracket NDPS case number 11/2019, whereby the appellant, applicant stroke appellant was, appellant has been convicted under section 20 in bracket small b stroke 29 of NDPS Act and sentencing him to undergo rigorous imprisonment for 7 years and to pay fine of ₹50,000 only, in default to undergo simple imprisonment for 1 year under section 20 bracket small b stroke 29 of NDPS Act. Full stop. The police prosecution case in this is that on 6/9/2019, the Search Inspector of Laluk Circle, District Lakhimpur, lost an affair before in charge of Silonabadi Police Outpost, citing alleging inter alia that on 6/9/2019 at about 7:15 p.m. on receipt of a telephonic information from his higher officials, he proceeded to Silonibari OP and found Prakash Lal Begi, Chiranjeev Borua and Ujjal Bhia, who intercepted and confined a tempo vehicle having no number plate, wherein 3 passengers were traveling, namely Niyatullah, Aziz Ali, and Noor Muhammad. Upon checking, who was the kid? Who was the child?
Son of my lord, petitioner of item number.
His name is not there.
His name is, my lord, specifically his name has not been given, most probably because he is below 18 years.
But there is no mention about one child.
Child mentioned, my lord.
But you have not mentioned in your petition.
My lordship.
You have not mentioned in your
Grounds, my lord.
3 person and a child.
My lordship. My lordship. 7. I I have mentioned.
In paragraph 2 of your petition, you have not mentioned that there was a child there.
My lord, para 7, my lord.
So why didn't you mention in paragraph 2 itself?
Para 7 of my petition.
Para 2, you have mentioned about the FIR.
FIR it is written, my lord.
Ah.
With regard to the contents of the FIR, I have stated, my lord.
There
Para 2, my lord.
was no mention of the child.
My lordship, most probably it is not there.
Most probably what?
FIR because, my lord, now this is come up in.
No, I understand that. But there's something.
Yes, my lord. So I have stated at para 7, page 8, my lord. That the son of the, my lord, applicant stated PW to Ujjwal Bhuya, who is the seizure witness come eyewitness, has stated in his examination chief that the accused applicant was only plying the vehicle where there were 2 more passengers on board, and the transport of the ganja was the son of the accused number 1, who was there traveling in the applicant's tempo vehicle, my lord.
Can you write along with one this 3 names I have given, no? Along with one more, along with a child. On checking the vehicle, the police recovered certain. Police recovered alleged ganja weighing about 2 kgs and 200 grams. 200 grams. After investigation, after the trial, the accused applicant, after the trial, after completion of the trial, by the impugned judgment and order, dated 5/12/2024, the accused applicant has been convicted as mentioned before, which is under challenge in the connected criminal appeal. Full stop. By filing the instant IA, the applicant has contended that there are several discrepancies in the versions of the witnesses in the instant case, which is apparent from the depositions of PW1 and PW5. PW1 and PW5. The applicants, then you write the counsel appearing for the accused, appearing for the applicant submits that the due to the discrepancies and contradictions contained in the versions of in the depositions of PW1 and PW5, the versions of so and so, comma, prosecution story cannot be relied on, and the judgment and order passed by the learned special judge is a special judge is not special judge is and don't write what was the last line? Prosecution story cannot be relied on due to the aforesaid discrepancies and the impugned judgment and order has been passed mechanically by the learned special judge in the instant case. The learned counsel has further referred to the reposition of
Lord PW 4, my lord.
PW4.
PW,
report which specifically says that the that that the applicant is in fact the driver of the. Is anything coming from
yes,
here?
my lord, PW3, it is, I'm sorry, my lord, PW3, my lord.
W3
The
specifically says that.
he was the driver of the tempo
uh,
and he had taken the persons carrying ganja in tempo on rent.
Specifically deposed, the PW3 specifically deposed that the applicant is in fact the driver of the tempo and the ganja so recovered was in fact from the passengers who were traveling in the tempo. He further submits that the child who was traveling in the tempo had in fact pinpointed one of the passengers who was carrying the ganja, and the ganja had been recovered from the person from the aforesaid person. Full stop. He further submits that subsequently the place of subsequently the residence of the child was also mm, also searched by the investigating officer, and certain amount of ganja was recovered from the mother of the child. Full stop.
My lord, that is PW2, my lord, earlier. That he was a tempo driver.
Yeah, one said.
I'm sorry, my lord, PW3 has.
PW4. I'll have to read the whole thing then.
PW3, my lord, he has said, my lord, the ganja bag was recovered from the son of the, my lord, Jadmoni, page number 53, my lord. Para 4, my lord.
What?
Earlier
The
point,
driver was that he was a driver said by
driver
whom?
PW2, PW2, my lord.
PW2.
PW3, my lord,
Yeah.
page 53, he has said, my lord, police checked the bag of all the passengers of the tempo and found ganja in the bag which was carried by the son of accused Janmoni.
Okay. Yeah, and then PW3 deposed that the ganja so recovered was in fact recovered from the bag of the child, bag that was carried by the child. Before you stop it there, stop it. In view of the opposite discrepancies of the learned counsel appearing for the applicant submits that he has a good case on merit and on merit and since the appeal has already been filed and is pending, the sentence, the conviction and sentence of the accused of the applicant should be suspended and the applicant should be granted bail at this stage till the appeal is disposed of. Mr. DP Goswami, what will be your submission? Mr. DP Goswami, the learned APP. On the other hand, submits that the ganja was recovered from the tempo which was driven by the applicant, and therefore his involvement in instant case cannot be denied. He further submits that there is no discrepancy as such in the persons of the PWs. Therefore, he opposes the bail at this stage. Full stop. This court, after going through the materials brought before this court and after hearing the submissions of the counsel appearing for the respective parties and taking into account the depositions that have been pointed out by the learned counsel appearing for the applicant, is of the considered view that the conviction and sentence so passed in the impugned judgment and order dated 5/12/2024 passed by the learned special judge, Lochinpur district, should be suspended in this stage until the connected appeal is disposed of. Accordingly, it is directed that the applicant shall be released forthwith on punishing of a bail bond of rupees uh, uh, 30,000, 30,000, which is security of like amount to the satisfaction of the learned special judge, Lakhimpur, not Lakhimpur, not Lakhimpur. Lakhimpur. In view of the opposite direction, the instant I is disposed.
Deeply obliged.
And this main petition, right? Let the matter be listed. After 2 weeks. 3 weeks, after 3 weeks. And Mr. Ahmed, your matter also after 3 weeks. Yours is already, you are on bail.
Hello.
Both the matters, next item also after 3 weeks.
Deeply obliged.
I'll just come back in 5 minutes.
May I please? Your Lordship?
Yes.
Lordship, in the last occasion, the Learned Counsel for the Revenue Department has referred a judgment that was passed by the full bench of this Honorable High Court in the case of Atwar Rahman versus State of Assam.
Yes.
But in this present judgment, there was some categorical findings of the Honorable full bench of this court, and this Honorable court held that, Lordship, the
Full bench of which court?
this Honorable Gauhati High Court,
Ah.
Atwar Rahman, and paragraph 14, this Honorable High Court arrived in a conclusion that the section 3 of the Societies Registration Act has issued the certificate for limited time, and it is for a time bound period. Thereafter, Lordship, it has no evidentiary value. And the second thing is that the power exercised by the Lordship register under section 3 of the Society Registration Act, it is quite administrative, not quasi-judicial. And under paragraph, Lordship, 17 of this judgment, the Honorable Supreme High Court held that, Lordship, an order of cancellation of certificate registration had been granted under section 3 of the Society Registration Act is an order within the meaning of order under section 21 of the General Clauses Act. It is an order that's that confines to the section 21 of the General Clauses Act. And applicability of the General Clauses Act mainly depends on which are the cases. The Honorable Supreme Court, in the case of Industrial Infrastructure Development Corporation Gwalior versus Madhya Pradesh Limited. Before I am coming to the judicial precedent, Lordship, I would like to refer first, Lordship, whether General Clauses Act 21 is applicable in the case of all registration.
All registration means?
All registrations which has been registered under various acts. Your Lordship may kindly come to the paragraph 20, 21, 22, 24 and 25. 20, in other words, the citation to 2018 4 SSC 494. In other words, the order which can be modified or rescinded by applying section 21 has to be either executive or legislative in nature, whereas the order which the CIT is required to pass under section 21.
CIT means?
Lordship, CIT is Income Tax Officer. CIT is required to pass under section 21A of the Act is neither legislative nor an executive order, but it is a quasi-judicial order. It is for this reason section 21 has no application in this case. the general power under section 21 of the General Clauses Act to rescind a notification or order has to be understood in the light of the subject matter, context and effect of the relevant provision of the statute under which the notification or order is issued, and power is not available after an enforceable right has accrued under the notification or order. Moreover, section 21 has no application to vary or amend or review a quasi-judicial order. A quasi-judicial order can be generally varied or reviewed when obtained by fraud or when such power is conferred by act or rules which it is made. Relying upon the 22, relying upon the
So registrar in your case is a quasi-judicial authority.
quasi-judicial lordship. In this regard, I will come to the Supreme Court ruling that was first made in the yes.
I'm just asking you.
Relying upon the aforementioned rule of interpretation, this court has held that the government has no power to cancel or supersede a reference once made under section 10(1) of the Industrial Dispute Act 1947. Is referred the state of Bihar versus D.N. Ganguly. Similar on same principle is it is held that an application of section 21 of the General Clauses Act has no application to amend or rescind or vary the notification issued under section 3 of the Commissions of Inquiry Act for reconstituting the commission by replacement or substitution of its sole member except applicable for a limited purpose for extending time for completing the inquiry. It is also held while construing the provisions of the Citizenship Act that the certificate of registration of citizenship issued under section 5 subsection 1c of the Citizenship Act cannot be cancelled by the authority granting the registration by recourse to section 21 of the General Clauses Act. And lastly, while construing the provisions of Representation of People Act, it is held that the Election Commission cannot by recourse to section 21 of the General Clauses Act deregister or cancel the registration of a political party under section 29A of the Act. For decision of the Commission to register a political party under section 29A 7 of the Act is quasi-judicial in nature. Paragraph 24, the issue involved in this appeal had also come up for consideration before the High Court, namely Delhi High Court in CIT versus Mulsan and Khairati Ram Trust.
25, come to 25.
And now, all the three high courts, after examining the issue in the light of the object of section 21A of the Act and section 21 of the General Clauses Act, held that the order of CIT passed under section 21A is a quasi-judicial in nature. Second, there was no express provision in the Act vesting the CIT with power of cancellation of registration till 1/10/2004. And lastly, section 21 of the General Clauses Act has no application to the order passed by the CIT under section 12A because the order is quasi-judicial in nature, and it is for all reasons that CIT had no jurisdiction to cancel the registration certificate once granted by him under section 12A till the power was expressly conferred on the CIT by section 12AA subsection 3 of the Act with effect from 1/10/2004. Now, the position is very much clear, I think, from the judgment. And then,
so what is the ratio? Ratio is that if an authority is a quasi-judicial authority,
yes, sir.
and which passes an order that cannot be cancelled or
cancel, and the order. The registration which has been made by virtue of an order that is not confined within the term of order, notification and bylaw, which is prescribed under section 21 of the General Clauses Act. It is not confined to the General Clauses Act.
No, it says about the CIT, right?
CIT. CIT, citizenship, as well as the People Representation Act, all has been discussed herein.
Discussed herein. They say that this is a quasi-judicial authority has passed an order that cannot be cancelled.
Yes, Your Lordship.
That cannot be cancelled by the same authority.
Yes, Your Lordship. once,
It is passed.
yes,
And General Clauses Act 21 will not be applicable.
applicable,
That is what it says.
yes.
Hmm.
And
Hmm.
so far the functus officio
Hmm.
is concerned, the Honorable Supreme Court, I would like to refer the
You
first
said,
judgment.
that this is a quasi judicial body, registration board, registration. Where is that?
Lordship, first I would like to refer the judgment that this Honorable Supreme Court has held that
Hmm.
the power exercised under under the Registration Act 1908
Hmm.
is quasi judicial because it is once it's signed, the authority of the officer functus Lordship officio.
In a functus officio, I understood.
Yes, Your Lordship.
It's a quasi judicial body. It is stated here.
Lordship, it
Is
is
there any is there any hearing happens
Lordship.
while registration?
Lordship, it is not, hearing is not required because I want to sell to someone.
No, I am just asking you.
Yes, sir.
Don't get hesitated. I am just asking you
Yes.
that, whether there is any hearing happens while registering any document.
No, Lordship.
No hearing happens.
No.
Okay. Okay. Now where does it say that it's a quasi judicial body?
Lordship, quasi judicial. In the case of Lordship,
Para 6 and 7 you record.
Lordship, that in the judgment that functus officio I have referred.
Hmm.
Lordship,
Okay, read what is functus officio.
Lordship, in this case, the rule of British. Yes. Your Lordship may kindly come to this judgment. Here, the specifically said that Lordship,
That is
referring to the judgment of the Lordship Satyapal Anand.
no, this is the
This is-
the government of Uttar Pradesh.
No, yes, Your Lordship, that is the judgment passed by the Honorable Supreme Court in the case of Government of Uttar Pradesh versus Raja Ram
Which paragraph?
Muhammad. In the judgment, Lordship, I have referred the judgment only because of that functus officio purpose, Lordship.
Okay.
And this judgment, Supreme Court has categorically discussed that, Lordship. Section 35 of the judgment.
Yes.
Para 89.
Para 89.
Yes, Your Lordship, page number 43.
Yes. This court in Satyapal.
Satyapal observed that Section 35 of the Registration Act does not confer a quasi-judicial power on the registering officer who is expected
Who is not expected.
who is not expected to evaluate title or irregularity in the document, such as the validity of the registered deed of extinguishment could be placed in issue only before a court of competent jurisdiction. On the above fact, this court upheld the dismissal of the writ petition by the High Court with an opportunity being granted to the appellant to pursue a remedy in accordance with law. Therefore, the decision of the Satyapal Anand has held that once a deed of extinguishment had been registered by the registering authority, the registering authority had no power to recall it, nor it was amendable to the supervisory control of the Inspector General of Registration under Section 69 of the Registration Act. Now,
But you said that it is not. It is a quasi-judicial body, but here it says it is not a quasi-judicial body.
Lordship,
You say that register is a quasi-judicial
Lordship.
body. Correct. You said register is a quasi-judicial body. That's why you referred to the other case, that case of this thing, industrial infrastructure. Correct. Industrial infrastructure. You say that only. Since it's a quasi-judicial body, an order has been passed by a quasi-judicial body. Therefore, Section 21 of General Causes Act cannot be applicable. That's what you say in the case of industrial, this thing, that industrial infrastructure development.
Yes,
Corporation.
yes.
Correct. Now, in this case, you say that that register is a quasi-judicial body, but it says register is not a quasi-judicial body.
Lordship, I have referred the judgment of the earlier judgment, Lordship referring that the order passed by the order passed under section 12A of the Act is a quasi-judicial order. I am not saying, Lordship, that he is exercising the power for exercising quasi-judicial.
No, no, if the person doesn't have the quasi-judicial power, how can he pass an order, quasi-judicial order?
Lordship, that is reflected in the judgment, Lordship. That's why.
Understood. But see, a person who has a quasi-judicial power, he can only pass a quasi-judicial order.
Lordship, in fact, Lordship.
No. Now
Yes.
this ratio that you have
Yes,
placed.
herein also
Now,
same.
now, see, you place this case arguing that that though in the other case which has been referred by Mr. Borpuzari full bench,
Yes.
they have taken the recourse of section 21 of General Clauses Act.
Yes.
He said by General Clauses Act, somebody who has a power to issue certain order or give a registration, then he has the power to cancel it also. And that was the ratio passed in that case. Because
Yes.
cooperative societies, probably in that case, cooperative societies, the register, once he has the power of giving the registration, he has the power of withdrawing also. That is what it said, correct? And that principle was laid down following saying that like General Clauses Act gives them a power, gives them a power, and that power can be exercised. And on the basis of that power, it can be cancelled. That was stated in the full bench.
Yes.
Now you stated you have submitted that in this case, this industrial infrastructure development, you say that this power that general 21 of General Clauses Act cannot be applied because it is an order passed by a quasi-judicial body. Then you say the registrar in this case is also a quasi-judicial body. That is why General Clauses Act cannot be applicable. But in this case, the case you have referred to now, it says that it is not a quasi-judicial body registered. So there is some confusion, isn't it?
No, Lordship, I have not, my humble submission is not that, Lordship. The here, Lordship, under paragraph
No, you
55.
tell me what is your submission about applicability of section 21 of General Clauses Act? You are saying that General Clauses Act cannot be made applicable into your case. Then why it cannot be made applicable? That is what the question is. Because he has, Mr. Borpuzari has referred to a case wherein he has stated that this power is with the registrar because under section 21 of the General Clauses Act gives the power.
Yes, Lordship, there may be, Lordship,
So whether this,
my understanding may be incorrect.
no,
Lordship.
your understanding may be correct, may not be incorrect, but what is your submission?
Lordship, so far here, Lordship, here, Lordship, as per the Satyapal Anand case, paragraph 89 reflects that the power exercise, power of the registering authority is not quasi-judicial to cancel the registered child deed.
So he is not a quasi-judicial body.
He is not a quasi-judicial.
So how this ratio of your this case, Industrial Infrastructure Development Corporation, will be applicable?
Maybe, Lordship, due to incorrect interpretation of the judgment, Lordship, I have referred. But so far the Lordship, paragraph 89, it is very much clear from the.
So 89 and Satyapal makes it very clear that once this is registered, the power is only with the power will be only with a quasi-judicial body or a judicial body, which is like civil court. That is what Satyapal and this court says.
Yes.
This other case says, right?
Yes, sir.
Now only thing is that Mr. Borpuzari is arguing that the power of cancellation is already there in view of the powers given under the General Clauses Act, section 21. It's your argument, right?
Power to cancel settlement.
Correct. For the section 21 General Clauses Act gives the power. That's what you're saying. Though no statute has given specifically, but if you take the recourse of General Clauses Act, that gives a power. That is the interpretation given by the.
And more particularly in reference to, my lord, the provisions of Assam Land and Revenue Regulation, that Purbutor withdrawal decision, I have placed it on the last occasion. This honorable court of the coordinate bench has relied on the ratio of, my lord,
that
But Supreme Court in Saktapal says that it can't be done.
it can be the lordship will kindly mark the subtle distinction here.
Now, what is the decision?
Yeah, distinction here is that, my lord, the district commissioner, that means the DC, DC has not touched the send it. Send it is still there. It is already there, executed. Once the send it is executed, my lord, it is registered even under the provisions of registration act.
No, correct. Now, if you argue that, then
Yeah.
where is the question of placing this case?
Placing this case, my lord, mutation. I am placing this case on the strength of mutation because it is the district commissioner who is the authority under the land revenue regulation to grant mutation, meaning thereby settlement.
Then he can cancel it. That's what you're saying.
Absolutely, I am so obliged.
You are
Absolutely.
saying that.
Yes, only to that limit. Sell it, executed,
Yeah, sell
sell
it
it,
is not
it is still there.
So we have.
Yes, there is no quarrel. Therefore, on the last occasion, Manat, I had made a categorical submission. No
I'm
quarrel
also-
with
I'm also-
Manat Sattapal Anand. Yes, yes.
Because said it was not touched.
Absolutely, absolutely. Sell it still remains. Therefore, he was given a leeway that you please regularize your sell it. You obtain the sale permissions, get it done properly, and my lord, that will be affected in the register. That can be done by a supplemental document also. That can be done. We need not advise my lord, the petitioner, but that can be done. So what the district commissioner has done, he has, once mutation is, my lord,
He has found the mutation in.
yes,
Because the document which are required,
yes,
those were not there.
absolutely.
But he has not stated that I'm cancelling this document because you have not procured certain pre-permissions, whatever.
Absolutely.
Permissions or like NOC, whatever.
Not a single whisper.
He hasn't cancelled it.
Yes.
He has only cancelled your mutation.
Mutation.
He's arguing that
Yes.
once mutation can be given, then that can be cancelled also
Yes.
by way of
This is precisely the order.
under section 21 of the General Clauses Act. That is, and he has referred to this case, Purbutter Vidyok handicraft. So where this the issue of land revenue circular is also there.
Yes. There, my lord, the state government granted, my lord, the settlement in favor of that Purbutter Vidyok.
That was cancelled.
Cancel. There no express provision in the Assam Land and Revenue Regulation. This honorable court taking key of, my lord, section 21.
Section 21 and what has been decided in the full court.
Full court.
That on the basis of that they have decided this.
Yes,
right? Yes, Mr. Sarma.
Lordship, in this case, my humble submission before this honorable court is that once a registration, once a mutation has been granted on the strength of a sale, if that consequence of the order has been declared invalid, then the mutation authority who mutated the lordship, the document name of the petitioner in the land record on the strength of the sale. It is very much clear from the order reflected.
I understood what you are going to argue. But
Yes,
tell me one thing, huh? Very basic law. You tell me one thing. One authority has somehow by mistake they have registered a document.
Yes.
And on the basis of that, a mutation has been done against the wrong name. You don't take it as
Yes,
dog.
yes,
Okay.
yes.
Some mutation has been done against the wrong name. Then certain factual things have come before that authority, clearly saying that okay, this was not correctly done. Don't you think like that there has to be some ways to rectify it, or it will be in spite of knowing that this has been wrongly done, it will be left like that.
Let's say the Honorable Gauhati High Court.
This is what I am asking you.
Yes, sir.
Don't you think that there will be some ways to do it, and that some ways maybe this whatever is done in the Purvottar case, that Purvottar Vidyok handicraft case.
Let's say here in some cases that has been decided by this Honorable Gauhati High Court, wherein the additional deputy commissioner lordship, he found that there is some discrepancies in the sale deed executed by the authority, and which was placed for mutation purpose, and accordingly he interfered with, and exercising the power section 151 of the Revenue Regulations Act, additional deputy commissioner has set aside the mutation. And the party thereafter appeal the order of the lordship the additional deputy commissioner.
Was
And-
challenged.
Yes.
Hmm.
And the revenue board held that lordship. Since the mutation has been granted on the strength of a sale deed, subsequently, irregularity of the sale deed or discrepancies in the sale deed cannot put question to cancel the registered, cancel the mutation from the land record, because the purpose of mutation is not for title or ownership. Title or ownership only granted by virtue of a registered sale deed, as per the section 57 of the Transfer of Property Act. And so far the other provision is concerned, section, if a person is aggrieved by that there due to some fraud or interlineation or for any way, name in the land record has been mutated by the settlement officer. In that case, the person, the right of that person is always open under section 23 of the Specific Relief Act. Whether when there is two specific provision and two specific acts that is relying for ownership on for deciding the ownership, and this power only only given to the civil court. The power
Now this revenue court, that revenue board's
yes,
revenue board's decision.
yes,
The board decision, I mean, whether it is before the High Court.
yes. Before
the
the,
what
in the
High Court
Deepak
has-
Kumar case, Deepak Kumar case, when the revenue board has says that you have no jurisdiction to entertain.
Yeah, correct. Revenue board, we are, I mean, okay, revenue board is, I mean, with due respect, revenue board has given a judgment, okay?
Judgment.
There is
And-
some interpretation. What has happened in the High Court?
High Court,
What is challenged in the
High Court has held that the decision of the revenue board is correct because there is a precedent.
Now, where is the case?
Yes, Deepak Kumar. I have relied in the,
In the list you have given?
yes, I have relied everything, Lordship. Because I know the only recent judgment, Lordship, that was passed by,
Chaudhary.
yes, only recent judgment, Rotinder Raskwa, Lordship, I have not placed. Rotinder Raskwa also I would like to place because the Honorable High Court has discussed all the points in this case, Lordship.
Okay. Para 34.
Lordship, in Deepak Kumar case,
No, Deepak Kumar, no, the other one, Ratindra.
Rotinder
Ratindra Raskwa. Para 34.
Raskwa, may, one second, Mr.
Yes, Deepak Kumar Chaudhary is referred here.
Yeah, yes, your Lordship. And here, Lordship, the Honorable High Court has held that, Lordship, on one paragraph is referring, but
Wait,
paragraph
wait.
13 has not been referred in this.
But in that case,
Yes, your Lordship.
there was an observation by the court, okay, that it says that para 34, it says that it is in the above factual background. This court has observed that when a specific remedy is provided under subsection 2 of section 53A,
Yes, your Lordship.
comma, the recourse to inherent power under section 151 cannot be justified.
Yes,
And therefore, exercise of inherent power under section 151 of regulation 1886 to undo mutation and cancel till the settlement was held to be invoked. So that was a different context.
Lordship, why I have
Because there, the power of inherent power of 151 was there. 151 was invoked, wherein a specific power is remedy is already there. That's why it says the court, the revenue board says that this is incorrect. We could not do it. But where is the ratio saying that no? I mean, once you have, I mean, though you have found the deed as incorrect deed without the formalities needs to be followed, the registered, the registration has been done. Then it was pointed out to the registrar, and then he has cancelled the mutation, or the settlement officer in this case he has cancelled the settlement. Correct. So in that case, the court says that no, I mean, like section 151, he should not have invoked. Yeah, because there is already a power provided under 53A. Then he should have taken that procedure to do it. So there must be I'm not very aware of section 53A, what is there, but that provision should have been followed.
Yes,
and by following that, he should have done it. That means what? That means the power is already given under 53A.
Lordship, my humble submission before this honorable court, since the deputy commissioner has, in pursuant to the direction passed by this.
You tell me, Mr. Sharma, I don't go here and there. You just clarify this point.
Lordship, on this point, only on this point, Lordship.
Let us go to the Deepak Kumar Chaudhary.
Lordship, on this point, Lordship.
Let us go to Deepak Kumar Chaudhary. What Deepak Kumar Chaudhary has said.
Yes, Lordship.
Let's see.
Deepak Kumar Chaudhary from the Lordship. Paragraph 20.
Let us see what Deepak Kumar Chaudhary has laid down.
Lordship, Deepak Kumar Chaudhary, I have referred paragraph 23 and 30. 13. Deepak Kumar. May I read, Lordship?
1 second. Lord. Deepak Kumar Chaudhary, which paragraph?
Your Lordship may kindly see paragraph 13 first. Paragraph 13.
Paragraph 13.
Yes, Your Lordship. The revenue board also.
1 second. Just wait for a minute. One second. No? Deepak Kumar Chaudhary case is not here. You have given some Faktom Tembi Devi. Then after that, you are supposed to give this as per your list.
List number 7.
Yeah, serial number 7. Serial number 7 is not there.
Deepak Kumar Chaudhary, what is list of judgment, Lordship?
That's what list of judgment. Those are list of judgment. Just one
Slip
second.
judgment. 22 and 14. Excellent must allow.
1 second. Wait. Maybe there. Let me check. No, it is not there. Deepak Kumar Chaudhary is not there.
Deepak Kumar.
Or somewhere else you have included or what?
Lordship, maybe.
You have not paginated, no, that's the problem. You have an extra copy? No.
Lordship, I am checking.
Can it be taken up tomorrow, Lordship?
Yeah, tomorrow, no, I don't have more that much. We have given sufficient time to discuss.
Yes, Your Lordship. Please. It would be-
But in this case, Deepak Kumar Chaudhary has been quoted. Let us see here. That take this, that case, Rathindra Raskwa.
ये कॉपी तो सारा करना page of 13 page of 13 and 23 and now this honorable court has made a query.
One second. The revenue board has also observed the settlement officer could not have cancelled the past notifications granted to the financial officer. And that the order of settlement officer has the effect of disturbing sale deeds executed long back in so and so respectively. On this basis, the order passed by settlement officer was taken to be arbitrary, and accordingly, the same was passed by the revenue board, which judgment so and so. Then 13 and
23.
Since the power was arbitrarily exercised to undo long executed sale deeds and cancel all mutations, then without. What are the other paragraphs wherein it was discussed? Here the case has come out as that
23.
the power was arbitrarily exercised to so and so. Then without any authority conferred title like civil court or a settlement court, I do not find any infirmity. So there may be something here.
Yes, Your Lordship. So there is specifically Lordship mentioned that he has interpreted the.
I find no infirmity with the impugned decision given by the revenue board to the effect that the settlement officer exceeded his jurisdiction and could not have declared the title and ordered mutation in favor of the petitioner, and that too without any material basis. There are some other things.
The mutation was granted on the strength of sale deed.
Correct, but they said that there were no sufficient materials were not there, nothing was there, it was adjudicated upon, then it was, and it should have been done in a different way. 53 is what? 1 second, 53 is what?
Here in this case.
1 second. A reading of the two sections of land revenue regulation amply shows that when a party is aggrieved by a mutation order of a subordinate authority, he can challenge the same under so and so, so and so. There is a specific remedy provided under the regulation, but section 151 is somewhat like a revisional and inherent power when specific remedy is available under the head. So this is different, Mr. Sharma. The case you have relied on is different. See, here 53 gives a power for appeal.
Yes, sir.
Then without following that power, he has gone under 151 and he has cancelled it.
Yes,
so court has said, no, statute has given you a power to proceed with this kind of case in this kind of event. You'll have to proceed this way. But you have jumped it.
Yes,
after jumping, you have taken 151, you have cancelled it.
Yes.
It has not stated that
Yes,
you don't have power. He said that you should have invoked 53A.
Yes.
Rather than invoking 151.
151.
So how this is applicable to your case?
Since the deputy commissioner in his affidavit in reply clearly stated before this honorable court.
Clearly stated that
he has exercised the power.
You get an NOC and we will do the needful.
Lordship, he has exercised the power section and 151 of the land revenue regulation.
Who?
Deputy commissioner. He admitted, Lordship, hearing.
But here, is there any appellate power here?
No, Lordship, he cannot.
He
can exercise the power 150.
Is there any, somebody has gone there to deputy commissioner to filing an appeal or something like that?
Lordship, since there was no hearing conducted.
So that's what I'm saying. The hearing will be conducted when you go with an NOC?
Lordship, the thing is that, Lordship, since the NOC is not applicable in the case of the present petitioner, pursuant to the amendment brought by the legislature, Lordship. It was there, Lordship. And
then what? Then 35 has gone back to somewhere, gone back to dark room. 35 GMDA.
Lordship, so far this GMDA is also not, Lordship, has been strike off from the applicability of the Lordship section 35.
Mr. Sharma, it will be, I mean, okay, we have heard.
And Lordship,
Enough. We'll see.
now only my final submission before this honorable court is that.
We'll
Since
see. I mean, you have a Supreme Court case in your
Lordship,
favor.
on-
I mean,
only,
let us see what is, I mean, what is the distinguishable factor.
Huh.
Mr. Barfuzeri has already pointed out one thing.
only
that
one judge, only,
a Supreme Court case is specifically on cancellation of the
yes,
registered sale deed.
yes,
But in your case, registered sale deed is not cancelled, but effect is almost same.
Lordship, he has already declared invalid and not sustainable in law.
He's saying invalid, but you can rectify it.
Once I did registered,
There are two things.
Yes,
One is
Lordship.
cancellation
yes,
and one is rectification.
yes, Lordship.
So he is saying that there was some mistakes. You rectify those mistakes, it will be a valid document. There is no problem. But till you do not do this activity of providing those NOCs, it becomes invalid. That's what he's saying. But he has not cancelled it.
Only
There
one,
are there are differences in cancellation and
Yes.
differences in saying that this is invalid, which is rectifiable.
only my humble submission to the respect, to this respect is that since the power of the deputy commissioner has been negated when at the time of execution of the sale deed, and now 3 years gone and new amendment has come, can deputy commissioner now issue a sale permission with a retrospective effect of the with a,
There is no
present amendment?
retrospective effect. He is simply saying, see, he has misread certain things. That is correct. But what he is saying is that if that power is gone from me also, but the power under GMD is still there with me.
Lordship, then Lordship, your Lordship may direct GMDA has also no jurisdiction to issue NOC, NOC without the NOC issued by the deputy commissioner. This is the law, Lordship.
That's what he is saying. That under the GMD, I have the power.
He does not have the power under the GMDA, Lordship. Deputy commissioner does not have the power. Your Lordship may kindly see section 32 of the Act. He
Section
does not,
35, what does it say?
he does not have the power, Lordship.
Now, under the GMD, NOC is required, whether you have got the NOC or not. That's what I'm asking.
Lordship, NOC,
Either DC or whoever.
yes, sir.
Under the GMDA, NOC is required. DC is saying that under the GMDA, NOC is required. That NOC is not given.
Yes,
When
Lordship.
when the registration was done, whether he doesn't have any right to say so.
Lordship, yeah, in this my case, Lordship, once the deputy commissioner cannot issue a Lordship NOC, in that case, no person can apply for the NOC from the GMDA, Lordship. That is the law. Because under the GMDA Act, there is
So
no
are you
prescribed law.
saying are you saying now the DC's power is taken away?
Yes, Lordship.
And since DC's power has been taken away, GMDA NOC is also not required.
GMDA cannot, the person cannot approach the GMDA.
Why?
Lordship, because to approach the GMDA, the essential document is NOC from the deputy commissioner, who determine the total revenue of the land. And out of that revenue, one person is required to be paid, and that is the essential document.
Read the GMD.
Yes, Lordship. Bylaws is there. Under the GMD Act, there is no provision.
No, your submission is that without getting an NOC,
Yes,
you
Your Lordship.
cannot apply before the GMD. You show me that.
Yes, Your Lordship. It is there, Lordship. Too much of document that is, Lordship, I have. He cannot, Lordship, in fact, a person cannot apply.
Yeah, that's show me that.
GMD.
That means without GMDA, without DC also, now everything can be done. That is what you're saying.
Lordship.
That means DC is DC's permission is not required. So DC's permission is not there, then you cannot apply to GMDA.
Yes, Your
That means there is no requirement of GMD also now.
Yes, that is there.
Show me that.
Essential document, Your Lordship will find.
No, you show me where this that precondition of DC's NOC. You show me that.
Lordship, in the entire Act, Lordship, there is no provision empowering the.
Tell me how GMDA certificate is supposed to NOC is supposed to be achieved. How it can be procured?
It can be procured by Lordship under Rule 5, Sub-Rule 3, 2 of the GMDA bylaws. Not under the Lordship, any. These are the additional documents required, Lordship. Because under the Act, Lordship, GMDA has no power to issue any Lordship NOC under the GMDA. Therefore, the Deputy Commissioner who cancelled it, Lordship, he also, Lordship, advised me to approach the GMDA, and GMDA in reply to that, without Lordship, NOC from the Deputy Commissioner, they cannot issue. And in that regard, Lordship, they have replied in my RTI, Lordship. The essential document, last part, Lordship. And in my petition, 128 page.
What are you selling your case?
Lordship.
In your case, what is you are selling? That RCC house, right?
RCC house and the house where is standing there on that plot of land.
Then here it says, in addition to the requirement as prescribed above, following additional document is required. Land sale permission.
Yes, because the Deputy Commissioner has admitted in the review petition that his power has been negated. He admitted in his review order. And once his power has been negated, Lordship, that he cannot issue the NOC. And if he cannot issue the NOC, GMDA power has been, Lordship, negated. And the amendment which has been, Lordship, categorically stated that all the power has been seized.
The power seized for what? Only for RCC building.
RCC
building and structures and features, not for land sale.
Lordship, I am not particularly sell a land.
In your document, what you have stated, in your agreement, what you have stated,
Your Lordship may kindly refer to my application.
Agreement, in your agreement, what was stated?
Lordship, in my
in your agreement,
yes,
sale agreement, what you have stated?
I have stated, Lordship.
See the schedule.
Yes, Your Lordship. A plot of land measuring 3 kotha covered by
Page 74.
Yes, Your Lordship.
Of the sale deed, my lord.
What is there?
A plot of land measuring 3 kotha.
A plot of land measuring 3 kothas, 0.00.58 lasses covered by duct number so and so of Kapipatta, number so and so of Blaze so and so.
So you are selling the land also?
Yes, Lordship, a building cannot sell because the power of Deputy Commissioner to issue a sale permission only in his aspect of Lordship land. He cannot issue a sale permission in respect of a building. That is the law, Lordship. And your Lordship may kindly see one thing. The Deputy, I have applied for this sale permission, Lordship. Accordingly, he determined, I have everything I have stated herein. Lordship, I have applied for the sale permission, and the office of the officials of the Lordship, settlement officer, he visited the place and took the measurement of the place. When he seen that Lordship building is standing thereon, he referred the case to the Deputy Commissioner, and the Deputy Commissioner held that since there is building standing over the plot of land, then power of the Deputy Commissioner has been seized, and he allowed me to registration, done the registration. I have talked to the authority, and it was executed on by me, not by anyone, Lordship.
No, what was the? It was 1 kotha something, right?
Lordship, I have.
So the building, the whole building is there in 1 kotha.
I have applied for the entire plot of land. Your Lordship will find my Lordship sale permission. I have paid accordingly the necessary fees. Your Lordship will find at page number 41 is the acknowledgement. It was the Deputy Commissioner who closed my application and allow me to execute the sale deed. Page number 41 of my petition, Lordship. And I have enclosed all the no litigation certificate and everything. The person went to my plot. I have also obtained, Lordship, non-incumbent certificate.
Page number 41.
Barpusar, he has applied for the land, but land with the house.
What the district commissioner has harped upon is, my lord, section 32 of the GMDA Act.
Hmm.
If lordship may be pleased to see section 32, it is explicitly clear.
Hmm.
GMDA is altogether a different authority.
Hmm. Yeah,
And-
but precondition is that bylaw says that in addition to the requirement, the land sale permission from deputy commissioner, if the deputy commissioner doesn't give the land sale, then how he is going to apply?
Deputy commissioner might have made a mistake that is altogether a
Mistake
different
he
thing.
committed, why
No,
should
no,
I
no, it
suffer?
is my turn. Sorry. It is my turn to submit. Please.
Sorry.
Deputy commissioner might have made a mistake. We are not on that. We are on, my lord, the mandate of law. Whether the mandate of law has been followed or not. As simple as that. Now here the district commissioner, I mean, my lord, the deputy commissioner has specifically harped upon, my lord, section 32. For a moment, lordship takes up
Yes,
section 32.
yes.
Yes, my lord. Section 32 of the GMDA Act, my lord. And so obliged, my lord.
Yes.
There is a prohibition. It starts with prohibition.
Prohibition of registration of sale.
Yes, my lord.
Hmm.
Prohibition of registration in certain cases where any deed or document required to be registered under the Indian Registration Act 1908 purports to subdivide any land or transfer of any land or transfer of any land. It comes within, my lord, transfer, this clause. Transfer of any land within the Gauhati metropolitan area. No registering officer shall register any such document unless the party presenting the deed or document for registration produces a no objection certificate from the authority to the effect that the authority has no objection to the registration of such deed or document. Now, this is the parent provision. What has been shown to my lord is the offshoot. These are rules. Rules may be here and there, but this is the mandate.
But the rule say now that 22 has come. Rule 22 has come. 22, right?
21A.
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 21A has been amended. Now, lordship, therefore, lordship, for a moment, kindly see, my lord, the amendment made to 21. That lordship will find at page 40 of the writ petition. I am going by the admitted position, my lord. But what are the admitted materials on record?
40 says.
40. My lord, this is the amendment. Their lordship will kindly, my lord, see down below.
Shall be replaced by this.
Yes, my lord, 2. In the principal act, in the third line, in between the words immovable and shall be, the following shall be inserted, except for house, flat, residential apartment, commercial building, or any construction or structure erected on a plot of land. It is so clear. It is so clear. That means, my lord, the indivisible part of a property which stands. Here is a case.
He need not take a permission for selling of the RCC building with the proportionate land area.
Had it been a case that, my lord, this is a plot of land over that, my lord, an
If
RCC building
is there, I'm
stands.
selling of this RCC building, then permission is not required.
Yes, RCC building, no, my lord, if he sells one of the floor of the RCC
You
building.
know, if he sells the whole RCC building also.
Yes.
Whole RCC building also, he will get the proportionate land.
Yes.
And if he sells one flat,
One.
then accordingly one that can be mutated against his name.
Yes.
That is the case.
This is the intention of
The land area is 3 kata something.
3 kotha.
And the RCC building is obviously like it cannot be that big.
Yes, therefore.
So therefore permission is required. That is your case.
Yes, and therefore permission is required more so because the schedule specifically says it is his document.
And in the application also that is referred.
Yes, my lord, a plot of land, it starts with a plot of land, then so and so, which RCC building. That means the dominating factor is the plot of land, my lord. So therefore, under 21A, he is required to take permission under two provisions of the statute. First one,
Now, that
20
only mistake I could find out that DC has commented some unnecessary things. He says
yes,
that
yes,
he's,
yes,
yeah,
yes,
he's
yes, yes, yes,
he's
yes, absolutely,
read properly.
absolutely,
And he says
absolutely,
something.
absolutely.
So that is the mistake he has
Yes.
done.
But
That is the mistake he has committed. But why are you saying that like why should you suffer for that? I mean, something has been wrongly given. You be fair, Mr.
Lordship,
You be fair, Mr. Sharma.
I'm Lordship, maybe Lordship, due to some.
And see, you are not being fair. That so maybe it shows from your this thing case that like you are arguing so much. I mean, I'm not talking you as a counsel. I'm talking your client. I mean, not fair because if so required NOC, go and take the NOC and give it to him.
Only,
Why are you not giving the NOC?
only 1
What's the
minute.
problem?
Only 1 minute, Lordship.
Huh.
Lordship, this citizen have right to approach the authority.
Now don't give me all this
Accordingly, Lordship,
citizen power, citizen this thing. Don't
and
give me.
accordingly, I have applied, Lordship.
Applied, you have not given an NOC and it was wrongly sealed, it was registered. And after detection, they are saying that you give me the NOC, I will rectify the sale date. That is the simple question and you are not doing it.
Lordship, how can I apply, Lordship, a sale permission? Lordship, that
Forget about that sale permission, whatever you got. Now they are saying that like in the sale permission, this is permission was required, it was not obtained by you. Now you obtain it, we'll rectify it. That is the case.
in the present situation also, Lordship, Deputy Commissioner cannot issue. In the present amendment.
I'm talking about that time.
That time, Lordship, he cannot issue because if your Lordship will go by the amendment of the section 21, then
Section 21, he has just read.
Lordship, he read only one part, Lordship. He has not read the subsequent part.
What subsequent part?
The subsequent part clearly says that the power of all the other Lordship necessary permission, that is not required. That is why my case, Lordship.
What other permission is not
Lordship, Lordship,
only one amendment has been brought in 21A.
yes, Lordship.
Inclusion of this except building RCC so and so. Other than that, what amendment has been brought in?
Lordship.
Other than that, what amendment has been brought in?
After that, Lordship, the amendment has been brought, Lordship, that if there is a building, then if a person can produce the occupancy certificate, then he can sell out with land. That is the amendment, Lordship.
That is your case.
And my case is not that, Lordship. My case is.
We are saying that like he has committed certain mistakes. The DC may have committed some mistakes.
Yes, Lordship.
But that's why like we should give you that liberty to go ahead with the, I mean, whatever is there without permission, without your, I mean, whatever, I don't know, whatever you have done, it should be allowed.
Only my humble submission before this honorable court is now that since this law is very subtle, that once a document has been registered, it deemed to be legally admissible and it cannot be subsequently disputed.
That is you are saying. Who is saying? That is you are saying it's a settled law.
No, it is Honorable Supreme Court has said, Lordship.
You are arguing that we will distinguish that. There may be some. He has already distinguished that.
He cannot.
He is saying
he has no right to distinguish that law. That is the law, Lordship.
Don't argue on these things. You have been sufficiently given time, and we are very. I mean, you should be kind to this court also. You should not submit certain things which are not supposed to be submitted. Okay. We have given you sufficient hearing, and like you are going on here and there and
your Lordship,
only because I thought like you are a young counsel, you are arguing. I've given you sufficient.
I'm sorry.
You started like going here and there and there.
Lordship, I am sorry for that.
It is not like that.
Lordship, I may be
come with a clear mind.
Lordship, I may be allowed to approach the Lordship the GMDA.
I will not allow you to do anything. I will pass an order. Then after that, whatever you do it. Whatever is required to be done, you do it after passing of the order. Heard Mr. D. Sharma, the learned counsel lecturing for the petitioner. Also heard Mr. R. Borfuzal, the learned standing counsel lecturing for Revenue Department, and also Mr. Goswami, Mr. B. Goswami, the learned additional advocate general for the state respondents. Hearing is concluded. Judgment is done.
I'm so deeply obliged.
Highly obliged.
Okay.